You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Hall versus the state of Florida.
Good morning. My name's Eric Pinkard. I'm here on behalf of Mr. Hall. There is substantial evidence in the record that Freddy Lee Hall has been mentally retarded his entire life. That was the judgment of the Circuit Court rendered on February 21st, 1991 in this case.
So here's the problem, though. The problem is that, again, when Atkins came out, I immediately thought of Freddy Lee Hall as somebody whose case would end up being reduced to life, frankly, because I had familiar with the facts. And that's different than a lot of our cases where mental retardation is never an issue, and then all of a sudden, post-Atkins, everyone's claiming mental retardation. So, but you seem to concede that the sum total of his IQ tests show a somewhat consistent pattern of over 70. Do you,
I don't concede that.
Okay, because I thought you were saying that for us to reverse here and find that Freddy Lee Hall is mentally retarded under our case law, under Atkins, under the statute, that we would have to recede from Cherry and the whole line of cases following Cherry.
Well, our briefing discusses that, obviously, but I'm not here. I understand what Cherry says and the cases after Cherry, so I'm here to argue that in this case, I think we're within Cherry.
So where did the judge go wrong then? I mean, this is the same judge that did find him to be mentally retarded his whole life as of 1991.
Right.
And now, 20 years later, we're saying he's not mentally retarded.
That's correct. And well, I believe, and we believe, that the Circuit Court's order is fundamentally unfair in the way that the proceedings took place, and also the findings that are within his order are unfair. Well,
I understand your argument that there should be a look at the adaptive functioning, because you cannot look at the IQ score in a vacuum. I mean, what does it really mean in real life? And it sounds like in real life, Freddy Lee Hall everyone thought of him as mentally retarded. But we still have case law that says you still have to get to that first prong.
Correct.
And so tell me how the judge went wrong in looking at the totality of the IQ scores. What I said to you was, don't the totality of the scores that we now have show a consistent pattern over 70? And you said no. So tell us.
Okay, well, we have to keep in mind that there's a statute in place, and that within the statute, which I believe that the Cherry decision has to be strictly followed, and with the statute, it talks about which IQ test and which kind of instruments can be utilized to make that determination of that first prong. And basically, what the statute says is it leaves it up to the Department of Persons with Disabilities to implement which tests and instruments can be utilized and which ones can't be utilized for that purpose. So,
are you saying that the IQ tests that were performed were not performed adequately or correctly, or?
I'm saying that many of the IQ tests that were relied upon by the Circuit Court in this case do not comply with the statute.
Which one do you feel they should have relied on?
Well, I believe, first and foremost, Dr. Mossman's 69 IQ, which is more than 2 standard deviations below the mean. He did that report, and he did that waist test, And that was part of a report that he submitted to the court, and the court would not allow Dr. Mossman's 69 IQ to be considered, or did not consider.
Well, he's deceased, and that you didn't establish the predicate. What was the evidentiary reason for that?
Well, there's two different reasons that the judge put in his order about Dr. Mossman's report. First is that he came to the conclusion, without any evidence from any experts to state this, because there was no expert called by the state in this case. It was the only expert called was Dr. Pritchard. But the circuit court judge said that Dr. Mossman's report lacked the critical detail and information indicating how he obtained defendant's intelligence quotient of 69.
And he never testified in any of the prior cases?
No, Dr. Mossman didn't testify in any of the prior cases.
So when Justice Barquette, and then relied on by Justice Anstead and myself, speak about the 60 IQ score, that came, that's from Dr. Toomer, and is that one a valid IQ score, or do you agree that under the department's construction that wouldn't that 60 IQ is thrown out? Because I was sort of surprised when I said, well, I thought he had a 60 IQ, and so what about Dr. Toomer's 60 IQ?
Well, I'm unfamiliar with which instrument Dr. Toomer used, but I'm going to go through all the IQ scores here in a moment and say which ones.
Revised Beta Bender Gestalt Adaptive Behavior Evaluated, whatever that means.
But before you get into go into the IQ scores, just so I understand your argument correctly, you're not asking us to recede on Cherry, Nixon, and those in that line of cases. What you're saying basically...
We've got a 69 IQ result from Dr. Mossman.
But you're relying on that IQ, you're putting all your apples in that one basket, that one IQ.
Well,
result.
I'm putting my IQ, not all my apples in that basket. I'm taking Dr. Pritchard's testimony about that IQ score.
Okay.
The full evaluation from Dr. Mossman.
Dr. Pritchard gave him a 71, didn't he?
That's right, Dr.
So, I mean,
Dr.
so Cherry's the bright line 70, right?
Cherry's a bright line 70, but I don't think Cherry says that if you have a 69 and a 71, you're out of court.
But there were other IQ tests that I think that's what Justice Perry, and one was Dr. Kopp, 73, Dr. Zimmerman, 74. I mean, and one went up to, I thought there was, maybe it was another case, 80.
Right, well, the 80.
Now, the problem is, you know, if clear and convincing is the standard. Is that not correct? And how could two, and it's not a quantitative, but even doing it not that way, how do you balance that if that's your line of attack?
As far as the 80 IQ score result, that test violates the statute because the person that administered that test is not qualified in the state of Florida to administer IQ tests. So we've got this bright line.
Okay, she was a graduate student. Okay, so you take
we got to follow the statute.
All right, take that one out, and you still
take
have
that one out.
Everything's gone over 74 or 75. Everything else.
Well, no,
except
71 by Dr. Pritchard is not over 75. And actually, the circuit court judge in this case, when addressing the IQ scores, talks about beta scores and Kent test results. Those are not valid under the statute. The statute is very explicit because the rules for the rules state that this department is supposed to select which IQ test can be implemented, and they choose the Stanford-Binet and the Wechsler Intelligence Scale. And it also says, shall be individually administered by a person that is authorized in accordance with the Florida statutes to perform evaluations in Florida. That 80 IQ you're talking about is not authorized by this statute. Now, we're going to use the statute strictly under Cherry and the other cases following Cherry to say that we have to follow the statute. This circuit court order does not follow the statute because when he addresses the different IQ scores,
excuse me.
I'm sorry, yes.
What were the scores that your client got under those tests you just enumerated that are in the statute and the rule.
Okay, well, we've got a 69 from Dr. Mossman. We've got a 70.
And that's under what is in the rule.
Absolutely. Dr. Mossman refers to, within his report, which test he gave. Contrary to what the circuit court judge says, Dr. Mossman explicitly talks about it. It's the WAIS 3, and within his report, he explicitly mentions and breaks down all the different categories of that WAIS 3. So we've got a bright line.
What else?
I'm sorry?
What other test?
Okay, well,
What other scores does he have under the tests that are specified in the rule?
You got a 69 by Dr. Mossman, 73 by Dr. Kropp, 71 by Dr. Pritchard, and a 72 by another doctor. So
How
the
do you
most recent
evaluate
ones,
that? How do you then evaluate? Is it when there's 4 valid scores? Who is then the expert that says that the sum total is that it's 70 or under, as opposed to over 70? Now, realizing that these doctors and the whole the psychology community says this is a 70 to 75 can be as much under 70 as, I mean, you know, they kind of criticize this idea that there's this number, but we've got to go with what the legislature, at least for now, what the legislature said. So how do you do that then? If you're appealing to us as trying to see where the judge went wrong, you're saying he went wrong by not considering Dr. Mossman's 69, but then there were, as you said, there's a 73, a 74, a 71, and a 72. Do you average, I mean, if you, I don't know, median, mean, whatever, that's, most of them are over 70.
well, the most recent ones made after the statute was implemented are 69, 71, 72. You average those 3 together, that's 70.66 average.
And this is,
So, but then when you go back, you're talking about the WAIS-R. People score higher on the WAIS-R.
what I don't
And we had
understand-
Dr. Pritchard, I'm sorry.
Let me ask you this question, because it really goes to, this is a crime that occurred in 1978. And we are now looking at measuring his IQ in 20, 30 years later. I read Atkins, and if you're going to say that somebody does not have responsibility for the crime because they're mentally retarded, which is generally somewhat of a static condition, but I don't understand, and I'm going to, how we don't look at the situation closest to the time of the crime, because I analogize it to that somebody under 18 can't be executed. Well, it's not 18, you know, it's at the time of the crime, because you're looking at whether they have the criminal responsibility. So do we have any evidence in this record of his IQ close in time to the crime?
Well, we've got the 60 mentioned in the opinion from the Florida Supreme
But
Court, from your court.
but that was okay. So that was 10 years after. Was that the first time he actually had a measured IQ? There's evidence in the record that the military did not accept him. They, you know, he was 4F because he flunked the intelligence tests or whatever. I don't know what level it is, but he flunked it.
Yeah, he was 4F'd in 1965, and
So do we know what his IQ, did he measure the IQ? Did the entire time that he was diagnosed as mentally retarded by the entire school system, did they ever give him an IQ test?
I don't believe the school system ever gave him an IQ, full-scale IQ test like the ones we're talking about in this statute. No,
Well,
that's
because they
correct.
probably weren't developed then. That's what I'm saying. But you got things that are now developed now that we're supposed to look at, and we're taking out earlier ones that aren't valid, but they're the ones that were used closer in time. I mean, this is a friendly question. You're looking
Right,
at me
I
with
understand, yes.
skeptically here, but
Yeah, no, I'm agreeing with you that
Didn't
you're
look like
right. I'm sort of in a difficult position because I'm trying to take a look at what the court's done in Cherry and the other cases,
Yeah.
and then.
I mean, it just seems that we're kind of we're struggling here, as I said, because I started out the conversation by saying that everyone assumed he was mentally retarded, at least maybe Mr., not everyone, but at least in the opinions it was assumed, and the judge assumed he was. But now we're going to say, no, he's really not, based on tests that came in, maybe 20, 30 years after the crime was committed. So I'm struggling with that.
Well, I think that's the credibility of the whole process to me is in question because of that, because you don't become unretarded over time. There was evidence, substantial evidence in the record, like the circuit court judge said, and if you take a look at any point in Mr. Hall's life, everybody's referring to him as mentally retarded. If you take a look
normally in these cases, there's something in the Department of Corrections that even though they are claimed to be mentally retarded, they're playing chess or they're writing these wonderful letters. Did the judge allow any of that adaptive functioning testimony at the hearing?
Actually, the judge did exactly the opposite of what you're talking about. He said that because Dr. Pritchard tried to go back retrospectively and take a look at the adaptive functioning prong, that was improper. He viewed the court cases from here as that you have to have concurrent adaptive functioning dysfunction. And so because Dr. Pritchard didn't go out and talk to prison guards all these many years after the offense in 1978, that meant that the entire adaptive functioning prong was not established. So that's one of the fundamentally unfair aspects of what the circuit court judge did on this. He explicitly did not take a look at all the adaptive functioning, and in addition to that, he said because there's no IQ scores, like you mentioned, because there weren't any offered back in the school system or by whatever reason, that you can't prove that onset before age 18. So the circuit court's order is riddled with these fundamentally unfair conclusions that he comes to based upon the record and then on the IQ scores that he relied upon that the statute doesn't allow. So he starts out saying we got to follow the statute, and then he immediately puts in his order IQ scores that, like the Beta and the Kent and the one that was given by the student, that shouldn't have ever been considered by the court in determining whether Mr. Hall was retarded.
Counsel, you're now well into your rebuttal time. You can continue, but you're using rebuttal.
I understand. I'll stop for the time being.
May it please the court, I'm Ken Nelly. I represent the state of Florida in this proceeding. Let me start, I suppose, to try to make this somewhat organized with talking about the evidence that was presented in 1991 at the resentencing. The IQ score...
And that's the resentencing where the judge ended up saying he'd been, that this defendant had been mentally retarded his whole life.
Yes, ma'am.
Okay.
Now, the evidence that supports that, and supports is in quotation marks, is an IQ score of 60 that Dr. Toomer obtained on a beta test. Now, I would suggest that if we are going to strictly apply the statute, as the defense keeps saying we are going to do, then that test is not fair game for consideration.
Well, are the tests that are used now, were those, this was done in '88, would it have been possible back then to have done the, the waist that's...
Yes, ma'am.
And back in 1991, when that test was offered, did the state object saying that is not a proper test to show mental retardation?
No, there was no such, there would have been no reason to object because there was no statute at the time that delineated them.
But do you see, and I know you've looked at a lot of these cases, but do you see that, is there not a fundamental problem if the whole premise of Atkins from the U.S. Supreme Court is that there is reduced culpability for the crime, and the crime occurs in 1978, 30, how many?
Long time ago.
Long time ago. Right, 33 years ago.
I was still in college. I don't remember back then.
yet we're evaluating the state of mental retardation based on how old Freddy Lee Hall is now, in his 60s?
He's in his 60s now.
Yeah.
I don't know exactly how old he is.
We're evaluating it based on how he's doing when he's in his 60s, whereas the time that would have reduced culpability would be in 1978.
Okay,
So is there something wrong with that?
There's a two-part answer to that, Justice Periente, and I'm really not dodging the question. But the first part of that is, at the time of the resentencing, Mr. Hall was given the WACE-R, the second version of the Wechsler or WACE test. That test was administered to him by a graduate, a master's level psychologist who was in the PhD program at one of the universities up in New York. Her name was Marilyn Feldman. There was substantial testimony at the time of the resentencing proceeding that it was wholly and completely proper for her to give the test. Now, if we throw out the beta, which the circuit court is being criticized for mentioning it in the order on the motion, even though the defense brought it out to start with, then that leaves us with a full-scale IQ score in 1991 of 80, which is not even close to being mentally retarded.
Well, but what about, did the state have offered that test?
The defense brought it out, Judge.
It was their test?
That was defense evidence to support mental retardation. And what I'm saying is, when it all comes down, when it all gets boiled down to brass tacks here, the finding of mental retardation as a mitigator was wrong. Now, I would suggest that mitigation...
It was wrong back then?
was wrong. There was no evidence to support it. Because if we're not going to count the beta 60, which the defendant is willing to throw that test out, then the only evidence is that he's a full scale of 80, which is, dull normal or low normal. Now, the second part to that, Justice Periente,
wasn't it Dr. Kropp? He gave, his test was in 1990 and 1991. So that must have been close to around resentencing.
Yes, ma'am, but like y'all have heard me say a bunch of times, you can't fake smart. And I would suggest that 80 on the Feldman WACE-R test is probably the high watermark.
Do you agree, though, on this, that it was done by a student who would not have been an authorized person?
No, it was done by a master's level psychologist who, my memory is, was in the PhD program. Dr. Dorothy Lewis, who testified also as a defense witness at the resentencing proceeding, testified at length that it was, in her opinion, as a psychiatrist, completely proper for Ms. Feldman to have administered that test. That's where we stand with that. Now, the other important part of this that really didn't became important, or is becoming important now, I suppose, is that in 1977, the definition of mental retardation changed. Before 1977, the DSM, I believe it was the 1 then, set the cut score from a diagnosis of mental retardation as 1 standard deviation below the mean, which would be an IQ of 85. In 1977, with the release, if you will, of the DSM-2, the cut score changed to 70, where it remains today. They went, in other words, from 1 standard deviation to 2 standard deviations. What that means in the context of this case, and probably likely not in any other case we're going to see, is that all of these comments back in the 50s are based upon a different definition than what we're talking about.
But in terms of, are we flawed in how we're looking at this because we're taking this IQ and we're looking at it in a vacuum, so that we would say that we have people that are showing IQs in the 60s or 70s, but they are functioning, and they seem to function their whole life. They held jobs, they lived on their own, they drove cars, they graduated high school, whereas everything that we seem to know about Freddy Lee Hall is that his life was one that we would, and we use the word mentally retarded. I know the recent thing is intellectual disability, I guess.
I think that's the currently in vogue term.
Yeah, I mean, I think it's the term that the psychology community, right, is using. But so is there, and would you say we just ignore that, or would you say that my thought about what, or my observations about what happened throughout his schooling, what his brother says, what all of those are actually, that's really not who Freddy Lee Hall was. He was actually a drug dealer, or he was this, what's the true story of Freddy Lee Hall, other than we know he's a murderer?
Twice over. But yes, ma'am, the diagnostic criteria for mental retardation, as established by the legislature, and as this court has interpreted what the legislature said, consists of three parts. Of course, the sub 70 IQ score, concurrent deficits in adaptive functioning, and onset prior to the age of 18. Now, this court has said that the legislature meant what it said and established a bright line score of 70 as the cut point, if you will. This court, and the court said that in Cherry and Herring last month, and very consistently over the course of this sort of litigation. Now, with respect to the adaptive functioning component, this court has said, rightly so, that the deficits in adaptive functioning must be concurrent deficits or present deficits.
Now let me ask you that. As you said, rightly or wrongly, because I have gone back and looked at Atkins, does it make sense to you that the concurrent means present? Because that could be a changing situation. 10 years from now, somebody's all of a sudden has, he could start to have Alzheimer's or, some other problems. That if we're going to be reducing,
but that wouldn't be mental retardation.
If we're reducing, but it would affect adaptive function. If we're reducing culpability, which is what Atkins is about, it's taking mental retardation and saying it's that person who committed that heinous crime, we're going to treat them as somebody that is less responsible because they're mentally retarded. If that's the case, how can it not be that you look at the situation at the time of the crime? Now, I understand the onset before 18 because you want to, if somebody ends up subsequently having a car accident and, their IQ is changed, but so you want something that's static. But in terms of looking at adaptive functioning, why would you look at what was happening 34 years later and how you function on death row as opposed to what was going on around the time of the crime? And I may have joined in the opinions that said it had to be present, but I looked back at Atkins. I don't know how that can be if the culpability is what you're measuring for the culpability for the crime, not your present state of functioning.
Well, and judge my response to that, and I don't take this as a flip response because it's not, but if you accept the defense argument that mental retardation is static, it doesn't matter. If you accept the claim that once mentally retarded, always mentally retarded, then it doesn't hurt the defendant if we assess his adaptive abilities now.
Except it's an unrealistic environment, the prison environment. And I don't know did you have prison guards prepared to come in to say that he's playing chess or writing poetry or, whatever
No, ma'am, we didn't go that route with this case.
Because probably, do you at all, I know, I don't want to use the word concede, but that...
No, I'm not going to do that.
I know you're not going to do that. But do you all see that this Freddy Lee Hall is different than a lot of the cases that you've been up here arguing, in that he appears closer to the genuine product of a mentally retarded person than a lot of the others that we've seen? It's not going to hurt your case. It's not going to hurt your case.
Justice Pariente, that this is probably the next to last case I'm going to have up here that's one of these old cases like this, because, Cherry's on its way back eventually. We finish it off next month. or this month, next month, I think. Anyway, this case is to some extent different in the sense that we have this finding in 1991, right in the aftermath of Campbell having come out 6 months before the resentencing proceeding, that basically said to the courts, if they, I'm paraphrasing, and I mean no disrespect, but they basically said if they put it out as mitigation, you got to consider it. Now, the defendant in this case came in and put on evidence that he had an IQ of 80 on an individually administered intelligence test, and the circuit court said, well, okay, he's mentally retarded, I consider it and give it a little weight. And again, I'm paraphrasing what the circuit court said in the sentencing order, but the fact of the matter is, we probably shouldn't even be here with this case because this man hasn't rung the bell with the IQ testing to get to the point of looking at the other parts of the diagnosis.
But here's the irony of it. Well, they say we shouldn't be here because we should have accepted the finding of mental retardation from 1991. Now, you said it's changed, and I had not known that, and that's helpful that the definition changed from 85 down to 70. What if next week the scoring changes and now we're back to 85? Is it now we have to go back to all of these defendants and look at, and this is why I think it's probably important that we look at adaptive function, that we find at least those that would meet the adaptive functioning deficit because that's going to be a much smaller group of people than those that may have IQs close to age 70, so that we at least so shouldn't we be encouraging judges to look at all of the three so that if this thing changes again, the number, we at least know those that are truly have deficits in adaptive functioning?
I think that would be trying to anticipate what the psychological community is going to do, and I don't have any indication that they're going to change the diagnostic criteria again.
But it's sort of like saying, though, if they don't meet adaptive functioning, it won't matter what happens if they had a 70, 75, or 80. If they're still, as the psychologist who testified said, is there are some people that have these very low IQs, but they're functioning at a very high level, higher level. And
Dufour is a good example of that because and this court decided that case and found that he was not mentally retarded.
Well, 4-3.
On the adaptive function.
It's what is happening in these cases is where we're making these judgments. We're not psychologists and trying to understand the full picture, and we hope we're getting it right.
Yes, ma'am, I understand that, but it's kind of like Strickland of the deficient performance prejudice prongs. The courts don't have to pass on both prongs.
But we feel better sometimes when we do. We look at it and we say, well, if they don't have deficiency or prejudice, we know we're in pretty good shape. If the judge,
sure, and when we get to federal court, we like both prongs. Certainly, we like that because that protects this court's judgment it gives it one more layer against being second-guessed down the road. But at the same time, fundamentally what you have here is a circuit court judge who addressed all three prongs, even though he didn't have to. He did. That's probably a good thing that he did do that. But I don't think the court, or if I'm writing the opinion, I don't know that I would require the circuit courts to, in every instance, address all three prongs of the diagnostic criteria.
But is it correct that the judge discounted Dr. Pritchard because he didn't go talk to the prison guards?
Well, it was a failure of proof on the concurrent deficit prong of it, Justice Pariente. It was entirely the retrospective evaluation that this court rejected in one of the cases I cited in my brief, and I can't remember the name of it.
Of all since Atkins has come along in the statute, we have, several hundred people on death row. Have the state agreed that any of them were mentally retarded or are mentally retarded?
It has never, short answer, yes, but don't ask me the names because I don't know them. I know there have been cases in which the state agreed that a defendant was mentally retarded and the case went away. But in the context of this case, under this court's precedent, which is what the circuit court had to follow, and which was the roadmap, this man did not score below 70, and that is candidly the end of the inquiry, or the inquiry can end there. And I would suggest that while we probably are not going to be seeing very many of these old cases like this, because I think most of the cases in which this issue is being raised are coming up under the rule at trial now. I don't believe there are very many left. There are few. But this court has interpreted the statute as the legislature wrote it, has directed the circuit courts to explicitly apply it in very, very clear terms, and that case law seems to be working well. There is no reason for this court to recede from Cherry, which is absolutely what this court would have to do to give Mr. Hall relief, because under Cherry, Mr. Hall loses, and that's all there is to it. It's that fundamentally simple. If the court has no further questions, I would ask.
I have a unrelated, sort of, his co-defendant. Did the co-defendant get life, Ruffin?
Yes, ma'am. I don't.
And has that issue about equal culpability, or where one gets life, was that litigated?
I would assume so. Back at resentencing, I don't remember it. I was, I came in this case pretty late. The opinion says what it says. It was a known fact, ma'am.
I said, by 1991, I guess you were a lawyer.
Not in this state, though. But, I believe it was litigated at the time of resentencing, but I don't have a crystal clear recollection of it. It wasn't really an issue in the most recent proceedings. I would ask the court to affirm the circuit court.
I'd like to address the adaptive functioning prong, because this retrospective analysis, I believe that this court has said is that you can't focus solely on age 18 or less when you're doing your adaptive functioning analysis. But in this case, we've got overwhelming and substantial evidence about Mr. Hall and his adaptive functioning or dysfunction when he was a child, when he went to school. His teachers repeatedly said he was mentally retarded up when he was age 9 and 10, 11 and 12, 12 and 13. Mentally retarded actually in the school records. He got D's and F's. And then when he was an adult in the military, 4F, he was thrown out of the military for not having the intellectual capability. And when he's 24 at the DOC, inferior intelligence by the Department of Corrections, and also at age 33, the Department of Corrections talks about he was showing little improvement and was mentally retarded in their opinion. And there was testimony from Mr. Hall's two brothers and his sister at the evidentiary hearing we had in this case, and they did talk about, in addition to when they would go visit Mr. Hall currently at the prison. So there was some testimony about what has been going on with Mr. Hall at the prison, not only from the Department of Corrections, but also from his sister and two brothers.
Do we have the letters? They were mentioning letters that were written and they were somewhat incoherent. Do we have those in the record?
I don't know if they're in the record, but they're surely incoherent from Mr. Hall.
Did anybody, when I'm looking back at Justice Barquette's dissent, and of course this is a case where we're focusing now on mental retardation, but this is the case where he was the 16th of 17 children and he was tortured by his mother in some unbelievable, horrible ways. Does that at all play into the mental retardation? In other words, what happened to him as a child and the the brain damage that is apparently documented, the mental illness, all of these other things? Or do we just focus on, this is your IQ test, you get there, you get out of death row and you're there, you are ready to be executed?
I would take the former of those two because to me, it goes into the cruel and unusual nature of the punishment.
What happened to the co-defendant? Is that something, co-defendant got life?
He did.
And was that litigated? That is the...
I recall putting that in a state habeas, I believe, about Mr. Ruffin getting the life sentence, and I think there's some mention of it in the resentencing order from '91, if my recollection's right. So, there's no further questions, I'll stop. Thank you.
Thank you. We thank you both for your arguments. We will now move to the second case on our docket, in re amendments to the Florida Rules of Civil Procedure and various other rules.
What a lineup.
Counsel, you may proceed.
Thank you. May it please the court. Good morning. My name is Keith Park. I'm from West Palm Beach. I'm the current chair of the Rules of Judicial Administration Committee. I'm here arguing on behalf of the RJA in place of basically Judge John Morgan, who chaired the subcommittee that did the vast majority of work on this, on the rule part. I see this as being sort of a two-part situation here, where one part we're talking about rule changes and the other part we're talking about implementation. I'm here to talk about the rule part. And from our perspective, and I want to go out of my way to thank Judge Morgan and the people that worked hard on all the committees putting this together, because it was quite an effort on their part.
Can I understand, just sort of to put this in perspective, I know the
Yes, ma'am.
clerks around the state have been trying, and now with the e-portal, to implement e-filing, and that's going along. And the clerks have at least told us that without it being mandatory, you're really going to have two systems, and it's not going to be efficient, it's not going to be effective. So we're really dealing here with the making this mandatory, correct?
Yes, ma'am.
And the other part is that somehow this has to work in conjunction with the e-service?
I think that's conceptually how it's been looked at, because all of the rules also refer to the proposed e-service rule of 2.516. And I think as part of that, the unfortunate reality is that for at least some period of time, we are looking at perhaps the idea of maintaining two files. I think the hardest part that both the RJA faced and the people that were trying to help the RJA was looking at these exceptions, which I find to be probably the most controversial part of what we have to deal with. We have a mandatory e-filing situation, yet we have, at the same time, issues regarding what might need to be maintained as original documents. I think part of that is going to work itself out over time. Part of it may require some statutory changes about what admissibility might mean with regard to some of these kinds of things.
I think what it is also, it's a conceptual change about how much we trust the electronic world. You'll see some of the justices have iPads up here, and we've got our summaries and the petitions on there. And with iAnnotate now, I can search the document. So now I see an advantage to it that is different than just, is it paper versus electronic? And I think the challenge, and I know that Manatee County has worked on it, is that what this electronic world has to be not only user-friendly, but it has to show both judges and lawyers that it is actually it's going to give them great benefits in how they do their work. And that's what we have to, so that's where I think the buy-in comes and the challenge for the clerks. If all you do is take a paper file, and now you take all those papers and you put it in, and now some judge has to search 2,000 pages to try to find what they could, go through their paper with, well, that's not improvement. On the other hand, you show and say, now you can go to this page very quickly, or you can find this term, now you've given an advantage. So I know that's not really where but I think that that's where the educational challenge also lies, is that if we adopt this and we address the issues that the criminal defense lawyers and prosecutors have talked about, that we've got to show that it works. So that's,
I certainly agree, and I think, unfortunately, some of these people we're going to drag kicking and screaming into the 21st century, but once they get there, they're going to,
well, there are some people, listen, my husband's not going to read a book on a Kindle. Okay, he's just not going to do it. He likes the book.
Okay.
But if we say, well, the book costs $100 and Kindle book costs $1, at some point someone's going to say, wait, maybe that makes some sense. Maybe not my husband, but some.
I'll talk to him about it.
Are you listening?
Yeah, but he does actually, he is reading on his iPad. I mean, it is interesting to see that. So, I think because it's important that we put the perspective that we have all these people here and all the rules committees, and what we're really talking about is making it mandatory, but everything has to work together. So do you want to address the exception in the rules? What were the exceptions and what were the concerns about, like, again, we have the probate committee doing a great job at saying, listen, wills and codicils have to stay in their original paper state. Do we have other things like that we say, no matter what else happens, this has to stay in its paper state?
I think, and as I said, as time goes on, I think we will find that these things will work themselves out, just like the probate committee, and they'll talk about that, worked it down to basically wills and codicils when they started out with a much longer list. And I think that was part of the problem we were having dealing with some of the other disciplines as well. And part of the problem has to do with, I think, eventually having items in, for instance, the criminal specter that are accessible for electronically, but are not part of the court file, and I'm not sure how that's...
But that's critical, and I thought they did a good job of showing that, and I'm not sure who's here from I see Mr. Jacobs, but that you need all those documents. If all you're going to get is something that is the plea form, but you need the arrest report, you need all the things electronically, otherwise, again, you're going to have this paper file to find some things, and then you're going to have to go electronically for others. But maybe that challenge is really within the criminal field, criminal lawyer field, to figure out how to make sure that they're all accessible in one place for one file at one time.
I think they are the biggest challenge, and probably the biggest challenge for getting online as well.
And they're the ones we didn't realize the last time. The legislature says you've got to do it. So I wish we had known that when we had the e-service, that already had been mandated to do this.
Now, if they just come up with the money for it, then you...
Well, that is important, and I think we've got to make that very strongly for both the process. I think one of the first times I ever see the prosecution, both sides agreeing that to do this, they need some resources. And
I think that may be one of the biggest issues that we have to face.
You've got about 30 seconds left. Is there anything you would like to address regarding some of the opposition?
No, I think there really isn't an opposition. I think we're all on the same page. The question is, with regard to these exceptions, how we're going to work with them. And I think we all agree that it's something that will probably work itself out better over time, and this may be a work in progress concerning this particular rule as we go along. And I think some statutory changes may well help some of that along as well. And some of the things that they're dealing with that will eventually become part of perhaps an electronic file somewhere along the line are really not per se part of a court file, just as some of the discovery that lawyers exchange in civil work won't become part of the file. Thank the court, appreciate it. And I would like to thank, by the way, the FCTC for all their fine work in this.
Good morning. May it please the court. I'm Don Scaglione. I'm the current chair of the Criminal Rules Committee. As Mr. Park said, we're arguing on behalf of pleadings that were prepared for us. Mr. Bob Strain, the past chair of the Criminal Rules, submitted the pleadings on this behalf. I see the court's interest seems to be a lot on the exceptions. I have reviewed all the documents. I have looked at the pleadings on behalf of Mr. Jacobs and the FPAA, as well as the Public Defenders Association, and I find that they don't really have a problem with the imposition. It's some of the exceptions that are there. The Criminal Rules Committee has made...
Let me just ask you a question, because part of the criminal problem seems to be is that they need to have a system where they can send batch files. And so are we talking about, when we use that term, what are we really talking about that they need to send? That are we talking about multiple documents for the same file, or lots of files at the same time, or what is it that actually encompasses?
Well, I have to concede that I'm not very technical in a lot of those issues. I assume from their pleadings they're talking about mass number of files to be delivered on individual cases, as well as numerous cases within the clerk's office that's there. The Criminal Rules Committee, made up of public defenders, state attorneys, appellate attorneys, and private defense lawyers, we reviewed their concerns, and that's why we drafted the amendments to the criminal rule procedure with those exceptions. As Mr. Park said, this is a work in progress. We're going to be working off of different files for a time period until such time that the legislature mandates sufficient funding. When I read the pleadings from the FPAA as well as the Defense Association, I see their main concern, or appears their main concern, seems to be the funding to be able to get this technology in order. I think all of us are in agreement that this would be a wonderful program. And I also agree with Justice Parente saying, the clerk saying, until someone mandates it, no one's going to take the step forward. But I believe our hands are tied, basically, if we don't have the funding to implement it. And until such time that two very large governmental agencies that's completely dependent upon the budgetary system of the legislature, as this court is.
Okay, and so, but we have two then major problems. One is this batch filing, which was referred to in the e-filing, e-service, and I think that we're, I don't know if the opinions come out, but they need to be looked at together. But the other is that your exceptions, which as I understand it, aren't because of workload issues, but because of things that you think need to be in the file. And so could you, I thought there was a lot of exceptions that you would say no matter what, they need to be in paper form. And so could you address those?
The exceptions laid out in Mr. Strange's response of interested parties, I think he laid them out and described them very clearly there. For example, the informations and indictments, as well as the original affidavits if need for follow-up. Well,
what is it, but what is, those are in every case. And so are you suggesting that what is the legal reason? I certainly understand with wills and codicils, I mean, we all feel like we better have that original. But I'm not sure I understand why the information, which is just a paper, is just something generated, needs to be the original, or the affidavits need to be, quote, the original in terms of a paper form as opposed to it being electronic. So
I believe that you'll find in Mr. Strange's response that there's a lot of statutory authority for some of these documents to be in writings and to be originals. I believe one of them he points out is affidavits of violation of probation.
So wouldn't that be the way we need to deal with it then? Is this session somebody, the same legislature that mandated everything be electronically done? It seems that someone needs to go back and say, this doesn't make sense. What I want to understand, are you a criminal defense lawyer or?
I was a prosecutor before I became the bench.
Okay.
He's a judge now.
Oh, I'm sorry. I mean, I'm not sorry you are, but what is it then, from having known all of this, that from a integrity of the criminal process needs to be originals, paper copies? That's what I want to understand. From, if this was a civil case, I can't think of anything in particular that would have to absolutely be in paper. And obviously the federal courts haven't. So what is it in the criminal realm that no matter what else, you had all the money, that, all of those, the statutes were there, that has to be maintained in paper?
Box me in the corner. Are you asking my personal opinion or as the chair of the Criminal Rules Committee?
I guess we always deal with as the chair, but it would help. I mean, we need the perspective of, of the experience that you would offer in that regard. So, if you want to be clear that this is what hat you're wearing.
I believe that we need to establish a uniformity across the state of Florida between the 20 state attorneys and 20 public defenders. I'm finding from reviewing how they operate around the state of Florida, there's not a consistency. What they do in Orlando is not what happens in the 5th Circuit or the 6th Circuit or Pinellas County. Until that uniformity is established in their operating procedures, it's going to be very hard to craft a uniform rule other than just mandating this is what the Supreme Court wants done. And this is how we're going to do it.
Give us an example of what you're talking about, because I'm not sure exactly what you mean that they don't have they don't do things uniformly.
Okay. Mr. Tomasino, I believe, who's here to argue on behalf of the Public Defender's Office, gave you a packet of information. I would say in my circuit, the majority of that information is not part of the court file. So that would not impact my county or my circuit in any way because they don't file those type of documents. So it should not be part of the court file. So that's just a difference right there in the attachments that he provided. So it depends on the jurisdiction that you're in.
So, but can you give an example of a document like a will or a codicil that in a criminal case must exist in paper, not because of the statute, but because we're going to have that as an exception. If the statute mandates it, we can't change that. That must be there for the integrity of the criminal prosecution.
I would say the arrest affidavit, the original arrest warrants, the original affidavits of probation, because they all have to be under oath, under signature. The original information signed by the designated state attorney or assistant state attorneys, as well as the indictments, which by rule need to be sealed until they are served upon the defendants.
But would there be a reason, so what would happen is those would get filed, could they be, they'll be filed electronically, but then we're going to ask the clerk to maintain the paper file? Is that how it would work? Because we certainly would want it to all be in, again, for the judge's point of view, it would be easier to have it all in one place.
I think this is, as Mr. Parks brought out, it's a work in progress. I think this will develop into a retention issue that once these documents are filed and held by the clerk's office or the state attorney's office or the moving party, that there would be the ability to dispose of them if there wasn't an appeal taken on the issue.
Well, wouldn't we have to have some kind of file anyway for physical objects? I mean, I know you can make a copy of a knife and, file it electronically, but you certainly need to have the physical knife or the gun or whatever other pieces of evidence that are physical there. And so to some extent, you're going to have something that's being kept that's not electronically. So are you suggesting that these original indictments and other things that you mentioned would be with those in that kind of file?
Well, the tangible evidence has to be maintained by the clerk's office. I think until you get to the destruction of retention of records, that the clerk's office must maintain all the tangible evidence there. And I think that can be separated out from the documentary evidence that the clerk maintains in their paper file. If there's no other questions, I see that I'm out of time. Thank you.
Thank you, Judge.
Good morning. May it please the court, I'm Buddy Jacobs, General Counsel for the Florida Prosecuting Attorneys Association. when I walked in this morning, the bailiff said, "Give us your phone if you're going to argue." And I said, "I'm not going to argue, but you can have my phone. I'm going to be inside." I'm not here to argue about anything. I think that everybody's kind of moving in the right direction. Certainly we as...
Let me make sure I understand. The prosecuting attorneys are not opposed to the December 2012 mandate for the prosecutors? Or
Now,
is that time period sufficient?
No, what I wanted to say was we're not opposed to what's going on. We are concerned about our ability to meet deadlines. And I think that's this is the legislature and Senate Bill Committee Substitute for Senate Bill 170. Senator Bennett, when he went through the process, was trying to say all these things will be done, and I order you to do that. The legislature orders you to do that. And we were able to work with him, and so what we have is a report that's due March 1st about where we are in this process and what the problems are. And we're working on that report. So I think that people are starting to realize that if you want all these boats to rise at the same time, you're going to have to put some real water under them. And right now, there is not any water out there. The bill that was to mandate us really fell back for the clerks on the local government.
What about what was just said about the difference in operating practices among the state attorneys that is sort of saying some of them want, or in some circuits you file all these things and others you don't? Let's leave aside the time frame, because we all say, well, okay, if by 2015 or whenever Mr. Regensdorf and I are ready to retire, we'll have this, because
I just hope I'm alive, that's all.
What is it, though, in the nuts and bolts that needs to, no matter how much money you have, has to be kept in paper? And I'm not, obviously, the physical evidence is, although videos certainly would be, and photographs will be greatly enhanced for the record if we can have those color there electronically. So what is it that on the exceptions that need to be maintained?
We're in a perfect world and we had all the money. I still say we'd have to sit in and work with people to work out what those things are. As an example,
give me, is it the arrest affidavit needs to always be in paper?
Well, let's talk about what's before you. The rule 3.030C says the things that should be originals are charging documents, indictments, informations, petitions, affidavits.
But why?
What
I'm asking, the probate people started with a long list and they got it down to what sounded reasonable. What is it that is necessary about all those being kept in paper?
Well, see, that's the proposed rule. Before you list all these documents, and then Senate Bill 170 lists other documents, I think that we're whittling them down from our standpoint. We can whittle them down a lot smaller than that list.
So what I'm asking you, as with your experience, is give me, no matter what else happens, must always be in paper.
I think the document list that were given to you earlier is a pretty reasonable list, but also we're concerned about...
I don't understand, but what is I guess I'm still not understanding why all those need to be in paper.
Well, the indictment, as an example, is kept under seal until the parties arrested, notified, or whatever. So information of that kind of a thing, that there is some, unless, and it's
why can't that be in the file under seal electronically?
And you said it best earlier. You said it's a matter of trust. Can we trust the system to maintain the integrity of those documents, number one? Number two...
Well, I'm sure people in Broward County, when they had the flood, would have been very happy if those were all maintained electronically.
Yes, ma'am, I don't disagree with what you say, but there is some concern about that. There's concern about perjury, ability to pursue perjury cases because of lack of original documents. Those are things of which we're concerned. But again, our attitude is such that we want to work with people to get it done. But as the writer H.L. Mencken once say, when they say it's not about money, it's going to be about money. And that's the problem here as far as we're concerned. We have wonderfully talented people in most every circuit, but our resources are exhausted. I think it's really unfair what the clerks have been asked to do without proper state funding. These are state issues, not local issues, and ought to be handled by the legislature in properly funding them. you're good at timekeeping. Am I over yet?
You're about a minute over.
I'm over. Oh, well, thank you very much.
That's what that red light there means.
It's difficult for me to say hello in 4 minutes, so I just want you to understand. Thank you very much. Appreciate it.
Good morning. John Tomasino on behalf of the Public Defenders Association, if it please the court. First, I thank the judge for giving me 2 minutes of his time this morning, so that's how much time we have. I want to we didn't come prepared to discuss the exemptions. However, fortunately, I have an opinion on it. I believe with Justice Pariente, the list is too long, and I'm not finding a rational reason. There's an administrative order by this court, technological access to electronic records in court. I believe it's Administrative Order 0930 that I believe gives the paper documents, once they're electronically filed, they inherit the rights of the paper documents. There is a way to e-notarize now in Florida statutes. It's 117021, I believe. So the problems we're seeing with the exemptions, we're not following. We believe it's already been addressed in other areas of Florida, business and commerce, and we got to bring the courts there. The public defenders are in support of this if we can get access to 100% electronic file. Our concern is, even when we talk about these exemptions, the police reports are not filed by a party.
But isn't that, okay, so, but is right now, it's filed in paper?
Yes.
In the court file?
I believe the initial police report, I would say 98% of the state, that is the first document that goes into the criminal court file.
That's a PC affidavit.
Right.
You're talking about.
The arrest report, the first
case
office,
report.
Who, what, when, where, and maybe why.
The case report usually is furnished by the police to the state attorney. The state attorney then, in discovery, furnishes that to the, so are you saying that you want that as well to be on the?
In our circuit, and from many other circuits that we polled, in all 6 counties in the Second Judicial Circuit, that initial report goes first to the clerk of court.
Again, you say initial report, you're talking about the probable cause affidavit?
Yes, sir. It goes directly to the clerk.
What I'm talking about, just to make sure we're on the same, is the actual report prepared by the police, which may be 300 pages or 1,000 pages long, that follows afterwards.
No,
Are you saying that, hang on. Are you saying that you want that particular report also to be online?
We believe that report, if it would come to us from the state attorney through discovery, that would be covered by e-service. It should not, we're not trying to add anything to the court file as the court file exists today.
Well, those reports are typically not filed.
The initial reports are not filed by a party, but they are in the court file.
We're going back to the initial report thing again. I'm talking about the big report, not filed in the clerk's office.
Mm-hmm.
State attorney has them, and they usually provide that to the defense in discovery.
Correct.
Now, are you saying that you want the state attorney's office file that particular report from the police to also be an e-file?
Not to the court file.
You want just the initial report?
We believe that should come as e-service. There's also probation reports.
Isn't the way to deal with that, is it to get, you got Mr. Jacobs, you got who represents the 20 state attorneys, you got you with the 20 public defenders, to try to get the uniformity, because, and it will enhance for the public defenders if something that's several hundred pages, instead of being copied, as you said, it can be sent electronically.
Mm-hmm.
That will be an advantage, hopefully, to you. Is that what you're, so what do you want us, I guess the question, and you're out of your time, is what do we need to do to either the rule or the rule of judicial administration that to address whatever concern you're raising?
We think that the rule needs to be enlarged to require the clerk to provide electronic access to the complete court file at the same time the parties are required to e-file. That solves it.
Mr. Baggett, is that, we need, okay, well, we'll find out from him.
All right, thank you.
He's next.
Oh,
No.
I thought Mr. Baggett was next.
May it please the court, my name is John Moran, and I'm co-chair of the Probate Rules Committee.
And I'm Tasha Dickinson. I'm the other co-chair of Probate Rules Committee.
We're before you this morning for the sole purpose of drawing your attention to an exception that's been mentioned several times already this morning relating to wills and codicils. The proposed rule package before you includes new probate rule 5.043. And it sounds like the court's well aware of this exception. Essentially, it provides that any original will or codicil deposited with the court must be retained in its original form and must not be disposed of or destroyed for 20 years after submission.
And we appreciate, the reason I brought it up is because we saw that what your Rules Committee went through, that you started with a very long list.
It was a difficult process.
Well, we appreciate that, though, because, again, it shows that what we're trying to do is comply with this, make sure we're not inadvertently damaging anybody's rights. And, again, I think we all appreciate that no matter what else happens, somehow that original will seems like that's important to keep in paper. Now, maybe in 10 years, we won't think so, but...
Our approach to this on behalf of the probate rules was to try to narrowly tailor this, and there were two reasons why those documents above others on those lists are important to keep in their original form. The first is that wills and codicils are initially deposited. They're not filed. But once a probate proceeding is initiated with a petition for administration, the clerk actually removes the will from that safekeeping deposit, so to speak, and files it in the court file. Now, with the rule as it's drafted, you could just, once that's scanned in electronic format, otherwise the clerk could discard anything that would be filed. We want to prevent that. The other reason, and perhaps it's more important, is that something that comes up in any will contest or litigation is the tangible evidentiary value of having the original will. Oftentimes, the authenticity of a will can depend upon the physical features of the document itself. For example, the testator's signature. A document examiner or a handwriting analyst needs to see the original. Sometimes they'll test the ink. It helps them provide
it's really
opinions
more like
that are reliable.
in a way, it's more like an exhibit, and I think we analogize it. In a civil case, you file a copy of the contract. Not until trial would you introduce the original contract, and so it's an exhibit in that way.
Exactly, Your Honor. In fact, not only is it the signature, but sometimes the ink is tested, the font is analyzed, the paper itself. There's been cases where pages are removed and replaced, and so that's why it's important to have that original on hand when those issues come up. So, again, it's a narrowly tailored exception. We believe it's extremely important for probate practitioners, and to the extent that any e-filing rule package is adopted by this court, we'd ask that that exception for will and codicils be part of the rule.
Do you want it to be, again, if there ends up not being a file because it's electronic, you said something about that the clerks start out keeping it, where do they keep it for safekeeping?
It depends.
Yes.
Well, that's really the key, though, is that you want that to be maybe where the evidence is in cases, because you don't want actually it in a file. I mean, once it gets the hole punches, it's not in its original form. It can be, people can be looking through it. They can be,
right now,
somebody can spill their coffee on it when they're
anecdotally, clerks deal with it in different ways. In Palm Beach County, the original will is right in there, and you can examine it. You can do the spit and thumb test on the signature right when you check out the file. But in other, counties, my understanding is there's boxes in the basement where the originals are kept.
I am sure that if we found out how paper files are kept around, if we really knew.
Our concern is just to make sure that any rule that's adopted doesn't allow these documents to be scanned and discarded.
Right.
Thank you.
Thank you.
Sorry, you said something about the spit?
It's the ink test to make sure it's original signature and not a copy.
You do that with all the files?
No.
I'll make sure to wear gloves next time I go to court.
Thank you.
Thank you.
Please the court, Paul Regensdorf. I'm wearing a number of hats today. I'm here.
Where's Mr. Baggett?
Well,
I know where
we're happy to go in that order, but I think Mr. Baggett and Judge Krieger may address more of the implementation. I'm happy to do that for the FCTC, but I got a couple of other hats. I may be able to help you on some of the rules questions. We're here about change. We're taking a court system and a bunch of lawyers and moving them from the old and moving them to the new, and there's going to be change. It's going to be a struggle, but I think it's eminently manageable. Will it cost money? In terms of cost, sure, we're going to have to train ourselves to do things differently. But the benefits to the system, and that's what you were talking about, really aren't in the e-filing. They're in the access. They're in the creation of that electronic record that we don't have. Then we can all use it, judges, lawyers, everyone. And that's the benefit. You ask people in the federal system who e-file every single day, none of them would go back to a paper system. So state lawyers who think paper need to think that there's going to be a tremendous benefit. Will there be some cost? Will there be some struggle? Yes. But the benefit in the long run is really unquestioned, both in costs and in improved access.
In the transcripts, there's a subdivision of the rule that says that the transcript shall be stored in an electronic format sufficient to communicate the information in a readable format.
Correct.
Is this going to mean that the entire, and because this all started because the appellate courts are going to e-filing, but we need the record electronically and we need it in readable form.
Correct.
So is this going to mean that the court reporter is going to file a electronic copy in a readable form, so that as opposed to the clerk having to scan in, like we have in some of these death cases?
Yes. I mean, will some of those documents still come in paper and have to be scanned in? Yes, but
how do the court reporters do it? Do they have to first do it? Do they do it electronically?
Absolutely. I haven't been to the court reporter in years.
So we ought to be able to save. Then I'm sure the court reporters won't be happy about this. But then there's no reason that they have to charge paper copies.
I don't want to get into the charges for court reporters. So that's a very interesting issue, but I think there's going to be the similar charges. But there may be savings there as well. Let me put my appellate vice chair hat on. The appellate lawyers want this implemented yesterday. They've got a July 1st starting point. If there's any group of lawyers, other than perhaps probate, that are ready to go, that really is an implementation thing. But let me take that hat off again.
But I will say this, that it's good. We can do this for perhaps, and again, we need to have the system ready. You can file something electronically, but unless you have the backup in the court, it's going to not be of any real benefit.
Absolutely. One of the main users of the electronic file has to be the judges, and that's going to be that's a social problem. Older lawyers and older judges need to change, and they're going to have to.
No, it's not that. It's actually developing, which we are doing, the infrastructure, whatever you call it.
The TIMS program, the other desktop programs for judges. But let me go for a minute to some of the questions about the exceptions, because there have been, I filed a response on that for the FCTC. There's two lists of criminal documents that are out there, and you need to realize the difference. One is in 3.030C, and Justice Periente, my feeling is, and this is what we stated, none of these documents have that level of significance that a will or a codicil does. It's just lawyers who don't want to change. These documents should be in the electronic file. So that is one list. The second list is the list that Mr. Tomasino, Public Defenders, put in his report or comment, and that is a different list. That's a list of documents, things that get into the court file from non-lawyers. They may be the police officer, they may be a Department of Corrections officer, maybe an examining psychiatrist. Those things today are in the court file. They get in the court file on paper. And Mr. Tomasino's point, he's absolutely correct, and I'm not sure the rule precisely addresses it, is that when those papers come into the court file, largely from non-lawyers, non-parties, if you will, the clerk, I think, is the only place to put the obligation, needs to scan them in so that not only the public defenders, but civil lawyers, prosecutors, judges have available in that electronic file the access to the entire electronic file. And so,
but couldn't we put the same requirement on third-party filers that if they can do it electronically? I mean, if we're talking about who would be filing these other than the state attorney?
Department of Corrections, pre-sentence investigation reports, a psychiatrist, psychologist.
Doesn't it go first to the parties?
No. Many of these documents go directly to the clerk and they get placed in the file on paper.
The Department of Corrections would be happy to file these electronically.
If this court has the ability to order all of those disparate agencies to utilize the e-portal, that'd be great. I'm not sure you do or want to on day one. Eventually they will, but that's the second list of papers, and it's in Mr. Tomasino's filing, that need to get into the electronic file so that it is usable. So
I'm not really following you. Why would the Department of Corrections send something and not send it to a party and just send it to the clerk's office? That just seems a little...
Again, I'm not a criminal attorney. I'm having to draw on people I've spoken with. My understanding is that who does pre-sentence investigation reports, for example?
But it's been my experience that those are sent to the state attorney.
I've been told that they sometimes go directly to the clerk's office. I may be totally 100% wrong, so maybe we exclude the Department of Corrections as a provider of documents as a non-party. But there are a number of documents, especially in the criminal file, primarily in criminal files, that get in there that may not get scanned. They need to get into the electronic file, and that's the second list.
I mean, most of third parties that are filing things, which sometimes they do in our have no right to be filing them to begin with. So we shouldn't be.
Separate issue. But let me address the bulk filing question that Justice Quince asked about a few minutes ago. Well, because as a lawyer now, I put on my bar hat, this really needs to be mandatory. We need to put a deadline and get people moving. One good example of that is that some of the criminal attorneys are concerned about bulk filing, which is largely, I think, filing repetitive pleadings in multiple files. It may be multiple pleadings in one file, but I think more often it's the same pleading in multiple files. And they're concerned about having to log in 50 times to put in 50 documents. Today there's not a solution, but because this mandatory nature of this is coming up, I hope, from this court, the FACC, and I can't speak for them, but I believe the FACC, Public Defenders Association, the Prosecutors Association have gotten together with their technical people, with their vendors, and they, I believe, would all tell you that this is a solvable problem, and they're working on it. The criminal side of the e-filing doesn't even begin, it doesn't have to begin until December 31, January 1, 2013. It's not mandatory under the FCTC proposal until 9 months later. That's 2 years from now. I believe every one of those organizations would represent to this court, and I will secondhand, that this is a solvable problem. That's the bulk filing issue. That really is the other issue. The one issue is these exceptions in 3.030C. I would suggest they're not significant enough to be on paper, and the second was the bulk filing.
If they are required to be statutorily there, it's covered by your exception.
Absolutely correct. In other words, if there is a statute that says for whatever reason the indictment shall be kept on paper or whatever, that's fine. But the point is, with confidentiality rules 2.0420 and sealing, and if there is something that needs to be protected from public view, that will be handled by an appropriate protective order, or the statute itself. I'm going to yield whatever rest of the time the FCTC has, because Mr. Baggett's going to, I think, address you primarily in implementation, then Judge Krieger. Thank you.
May it please the court, my name is Fred Baggett with the law firm of Greenberg Traurig, and I am here as general counsel to the Florida Association of Court Clerks.
And we really, thank you for being here. What we really were concerned about is that we were presented with this rule, but really the implementation is the key. And we wanted to make sure, it sounded like, and it's a wonderful thing, and I thank you and your association, that you and the FCTC have really agreed on what is a reasonable implementation schedule. I just wanted to hear it before the court that yes, this is doable, and that the commitment is to continue to do as much that the clerks can do to make this a system that is not only is efficient but also superior for all of the citizens of the state.
Justice Barrientos, the answer to your question is yes. At the request of the FCTC, the clerks and their technical staff determined what were the reasonable dates within which clerks could be ready to receive e-filing on a statewide basis.
Because what you said to me, and it's not in connection with this case, is that unless we make this mandatory, this whole thing isn't going to work.
There's no question about that. If we don't make it mandatory, the cost to the clerks and to the courts will increase significantly due to the fact of having to keep two sets of files, an electronic file and a paper file, and the difficulties that would create.
Mr. Baggett, when we're talking about e-filing and making all of this mandatory, are we still talking about the e-portal also?
Yes, ma'am.
And so, as I understood these documents, there are a number of clerks' offices that are not prepared yet to take documents through the e-portal. And so what kind of schedule is there for the clerk's offices to be able to get these documents through the portal?
Well, first of all 67 counties have had their e-filing plans approved by this court for either all or some of the case types. We have 10 different case types, and so all the clerk's e-filing plans have been approved. As of November 1, 41 clerks are accepting some case type e-filings through the statewide portal.
Okay.
There are 5 clerks who maintain local e-filing systems that connect to the portal. They are not yet receiving from the portal, but are connecting to it. And we have 21 clerks who are in some stage of progress in their connection to the portal. We have determined that while it is an aggressive schedule, the clerks are committed to be capable of filing all civil cases through the portal no later than July 1 of 2012, and all criminal cases, the 5 criminal case types through the portal no later than December 31, 2012.
And I understand that either the clerks or the portal authority are working now on this bulk filing problem. I think is there a pilot going on in some of the circuits?
Yes, ma'am. Well, we have been working with the state attorneys and the public defenders on issues that they have raised, the bulk filing being one of them. We are looking to pilot that program in the very near future.
Something that would actually allow them to, with one push of the button, it's going to
Yes,
go
ma'am.
into, I mean, that may hopefully make that much easier for them.
It makes it easier for them. It makes it easier for the clerk. It
I
makes
can't
it easier for
imagine
the
if you
court.
had 1,000 filed in one day and someone has to be there putting the paper in 1,000 files and somebody had to print out 1,000 files, bring it over versus it's all there, it's the same form in different ways. Push the button and it's in 1,000 files.
That issue will be solved well before the proposed mandatory dates for criminal filing. Yes, ma'am.
What about the transcripts? Are those going to be electronic?
It is my understanding they will be electronic.
Through the court reporters sending them to you
Yes, ma'am.
electronically? Because I envision, and this is from the appellate point of view, that the record then, if it's all in the file electronically with a push of the button, comes to our clerk, and now we have the entire appellate record without having, is that going to happen?
We have been working with your clerk, Tom Hall, very closely, and we feel that the progress that's been made in the appellate e-filing process is probably ahead of everything else, and that has been a priority of ours. We do need to understand, I would hope the court understands that e-filing is not the same thing as an e-court system. It is a component of an e-court system. It is merely a highway to get a document from point A into point B. The clerks have to, and their biggest challenge here is in their development and implementation of their electronic case maintenance system, to put everything in and for them to be able to, as they do in a paper file today, sort of coordinate that file together. Similarly, the challenge to the courts being their case management system, which the clerks are working with the courts on and helping to develop so that there is a common use of the electronic case file that the clerk has developed in their maintenance system. There is a consistent and friendly use to the court of that. So this is the beginning. E-filing, none of this can happen until we get e-filing. But e-filing is not the nirvana of the e-court system that we all are looking forward to. So as I heard earlier today, it is a work in progress. If I could take just a minute to address a couple of the issues, particularly the non-party filings. That's happening today. Sarasota County, with your permission, with the authority from this court and their chief judge, Sarasota County is an electronic court system. The clerk there does not have paper. She has now been receiving e-filing at a local level for 10 years and has evolved her office to where if a third party comes in with that initial arrest report. She simply takes it, scans it, puts it in its proper place in the e-file, and gets rid of the paper.
What if it's the original affidavit? What if it's the affidavit, you know, the...
My understanding, the affidavit goes into the e-file. I hope I'm not wrong there, but she does everything.
That's Karen Rushing?
Yes. And if there are any needed statutory tweaks to accomplish electronic signature, clarify electronic notarization, the clerks have this year pre-filed and have their sponsors for, in both the House and the Senate, for a general housekeeping cleanup bill that focuses primarily on enhancement of collections, which we all are interested in for different reasons, but collections and the migration to an electronic system. And it is more than available as we are working with the parties to accommodate any of those tweaks that need to be done.
There's some things like fingerprints on booking slips.
Yes, sir.
For example, I know like when judges face a charge or presiding over a charge of firearm by a convicted felon, for example, the comparison, the identification of the convicted felon is done through comparing the fingerprints in the booking slip with the fingerprints that taken in open court.
Mm-hmm.
And that's usually done like in the courtroom. So you need to have the actual booking slip with the actual fingerprints. I don't know that an expert can compare prints from looking at a screen on the computer. So there are going to have to be some documents that need to be there in paper. Otherwise, you're not going to be able to prove.
And evidence, as we heard before, evidence is a physical happening. A lot could depend on what this court does in the rules as we go through the next 2 years.
But booking slips are not evidence in the sense that we're talking about photographing a knife or photographing a gun or whatever. This is usually when you get booked, what they take from you at the booking desk, and that gets filed into the court file. And that's how you prove this one charge.
The point being, based upon this court's determination, that kind of necessary physical document could be considered similar to evidence in that it be maintained separately. But to have two separate records is just, we might as well not be doing this.
Let me clarify something for,
Yes, ma'am.
in Sarasota, the criminal cases are filed electronically also?
My understanding.
And so they're not keeping the indictment or that list of documents that
Justice Quince, I don't want to say that. It's my understanding, and Clerk Rushing has confirmed that she is operating a paperless court and receiving. Now, I can confirm that to you and submit it to the court afterwards. In fact, I will have her do that if that's acceptable to you.
Since we've had so many questions on the criminal area,
sure,
it would be helpful, I think.
And we're very sensitive to the criminal side.
Mr. Baggett, we thank you. I want to express my gratitude for all the work the clerks have done on this issue. This is an important issue, and it's taken a lot of people. We appreciate the cooperative effort that's been made and the great collaboration that the judicial branch has had with the clerks on this.
Well, thank you very much, Mr. Chief Justice.
Good morning. May it please the court. I'm Judy Krieger, as you know, the chair of the FCTC, and I guess I'm the cleanup crew this morning. There were a number of questions that were asked that I'd just throw in additional answers to. I also, first of all, I think you all should know that the commission was unanimous in accepting the deadlines that the clerks assured us that they could meet. We had a very lengthy discussion, thoughtful discussion that resulted in the resolutions that came out of the late September meeting, and the commission wanted to say 100% that it was behind this rule, that it was given timeframes by the clerks that the clerks felt that they could meet, and representatives of the criminal practice area as well as judges who sit regularly on the criminal bench participated in the discussions with regard to the additional time that the criminal practice area would need to work through some of the issues that were raised. I think the Commission recognizes that there is a narrow category of documents that should be maintained in paper format because they may be the basis for a later legal action, similar to the wills, pardon me, the wills and codicils. Fingerprints may very well be an example of that, but a verified document or an affidavit, if you have a rule that says that a verification, a verified instrument can be the basis for a perjury prosecution, and the statute that defines the crime of perjury includes that verified document, whether it's in paper or digital format, you've taken care of that problem.
But
So
that's not for us. I mean,
No.
that's not for us. And the other issue is if someone contests that it's not their signature.
That-
so
yes, ma'am.
But is that right now dealt with by the rule itself that says that, first of all, a judge can always say, if the interests of justice require it be filed in paper, and it also says that unless otherwise required by statute.
Yes.
So is it the position, and I just want to make sure, Mr. Regensdorf, I mean, obviously you're in the same commission here, but that the exceptions in the 3.030C are not necessary?
Not all of them.
Okay, which ones?
Correct. And I think...
Well, how do we decide which ones if they're not all?
I think it would be presumptuous for me specifically, based on my personal experience, which it does not encompass broad experience in the criminal practice area, either as a lawyer or as a judge, that for me to take that critical eye and say which documents would be very difficult.
Well, why don't we then, on that one, send that back to have all the wonderful minds in this room work to narrow the list so that we can get to, rather than try, I mean, this is a work in progress. We also have that March report by the PD and the state attorney with the legislature. So wouldn't that be a better way to do that?
It may be with a short answer time. As I said in the supplemental comment that I filed on behalf of the commission, when I first received the court's order, my first thought was to work, as I've similarly worked in constituting work groups to deal with discrete issues that the commission deals with, to put together a work group that had 4 out of 12 or 13 members from the criminal practice area to look at that second sentence of the August 7th or August 8th order, and to physically get that group together in a very short turnaround time was difficult. We started to address those issues collectively in 2 meetings that we had by video conference, and I think it would be helpful perhaps to send that back for a relatively short period of time, but enough time to give a group, a small group of representative people, an opportunity to fine-tooth comb the list.
Right.
I do think it can be narrowed down.
This is the kind of thing that if I had my druthers, we'd all be sitting here and just try, rather than doing it in a formal way.
Oh, that's very funny that you mentioned, right? Are you laughing or what?
Because you said that same
Here
thing.
was my thought last night, which I communicated to those of us who assembled this morning. How about asking Keith Park, who was the first one up, to come to the court and say, you know, this is really about 2 things. It's a rules thing, but it's an implementation thing. How about respectfully suggesting to the court that we suspend the ordinary adversarial procedural presentation for this particular subject matter and come to the court and say, we're here collectively to answer your questions, and then take your questions, but it was rejected by some
Well, I
of
think
us.
that, let me say this, on the implementation issue,
Yes.
my belief is that we, in our rule, we need to say it will be mandatory as set forth in a separate administrative order, because, and then that will allow us through that administrative order that if Mr. Baggett, if any of you go, oh my God, we really can't do August, we could do this month, we don't have to come back and amend the rule. So that's what I'm thinking, and then it's going to be, have to be in the Florida bar that this is the time, and we'll put it in our opinion, but we're not going to put, we won't put the date in the rule. So that will allow us to discuss implementation. And frankly, the reason we asked for the comment was that you had said in your report that the court should figure out the phase-in plan. And I'm going, the court doesn't know this. We need the clerks to tell us and the lawyers to tell us. So this is why we need, and the same thing with the rule. Justice Labarga has vast experience in the criminal areas, just as Quince, but it's really what's on the ground, what legally is required. The way I see it, and I'm hearing it, I don't see why any exceptions are necessary that unless they're covered by your rule.
Well, let's
you can go back and look at
let's
that.
critically look at the rule. The rule at this juncture requires attorneys to e-file, not third parties, not pro se self-represented litigants, only attorneys. So the types of things like pre-sentence investigation reports, A-forms, those are not documents that are filed by lawyers. They're filed by third parties. The commission was not ready to go to a drop-dead date for third parties to file electronically because there are too many things that need to be worked out about that.
I'm not talking about that. I'm talking about 3.030C, the list, their list. I
Yes.
thought you had there had been the Rules of Judicial Administration Committee said no, none of those documents have to, should be in paper. And so that's what I was trying to deal with, not the third-party situation.
Okay, I'm sorry, and I was focused on the mandatory e-filing. No, I think that if you sent back that list with the directive to report back to the court within some number of months, that can be fine-tuned. I think the part of our calculation of the implementation plan dates included recognizing that there are probably other rules of procedure and/or judicial administration that will need tweaking in order to migrate into digital record keeping and working with digital records, as well as legislative tweaking, which won't happen this session, but we allowed enough
Mr.
time
Baggett
for the
said
next
if there's
session.
something
Well,
that
he
needs-
has his bill,
Well,
but
maybe he can amend his bill to put some of this on. I mean, let's
And
try
I-
to get what we can get done this session so we don't have that problem.
no question, but I don't know that it can be ready for this session. We felt that we needed to allow one more. This is a redistricting session.
Oh, I forgot
As a
that.
practical matter, we didn't know that it could all be accomplished this coming session, that give it one more in order to go through that process and to go through the rulemaking process that has to come up to the court. So we considered those things in the deadline. We were informed about the batch filing situation. It was first addressed to me by Carlos Martinez, the PD in the 11th Judicial Circuit, and I know that Harvey Rubin, the clerk in the 11th, had already developed some kind of a mechanism to allow for that in the 11th Circuit. So it's already being discussed with the portal people, and the portal people are going to be able to work that out. I don't think that's going to be a problem given the period of time we've allowed for the criminal practice area. The big ticket issue is the resource issue in the implementation plan. I look back at the legislative reports that accompanied the bill that made it mandatory in the criminal practice area, and interestingly, the legislature did not do any real fiscal impact study to see how much it was going to cost, and this is like, it's sort of typical to me. And there is an upfront expense in order to realize what we all anticipate is ultimately going to be a cost-saving measure across government by this transition. One of the things that's recently been accomplished is that the court administrator has gotten a grant from the State Justice Institute to engage a consultant with financial background to do a cost-benefit analysis of how much it will cost the court system to get there into e-courts. It'll take some time, but we will have that information. Finally, the educational challenge. That is something that we've been discussing internally within the commission and with court education department. There is a reluctance. Lawyers, judges, folks are slow to change sometimes, and there's going to have to be an educational period. I experienced this. Most of you know that in the 11th Circuit, the Family Division operates with electronic documents and has since November of 2008. And it took 3 years for that of planning for that to happen. The tech people had to develop the programs. All of court staff and the judges had to be trained to use them. I think it was Paul who said before, or Fred said before, that e-filing is all well and good, but unless we get to the point where judges are given the case records in a way that they can work with them uniformly across the state, it really doesn't do any good to have e-filing, because all that happens if you don't have the way to work with the documents is that you've shifted the burden of printing the paper from the filer to the court, and that doesn't do any of us any good. And
I understand Manatee County, that Chip Shore is really, not finally, but I think the chief judge there is very happy with what they're about to be doing.
They are, but there's some real wrinkles to that. From what I understand, although Chips has been saying that his system, which he calls the Lego system, because you can snap it on to any case management or case maintenance system, that it's not quite that simple to overlay it onto every one of the vendor systems that's out there, number one. Number two is that we have to address internally, and we have a committee of the commission that's working on this, which is the multi-county circuits, and having uniformity in the multi-county circuit so that the chief judge, for example, can uniformly view the case files and what his judges or her judges are doing in each of the counties, and not have to go to 6 different case management programs to look at what's going on out in the field. Or if a judge is riding circuit and is sitting in several counties, the judge doesn't have to suddenly, you're viewing it this way in one place and another way in a second place and a third way in a third place. That's one of the challenges that confronts us when the clerks have been individually buying their case management and case maintenance packages, and we can't change that. We just have to address it so that line judges can do their job efficiently, the administrative judges can do theirs, and the chief judges can do theirs, and you all as the overall supervisors of the judicial system can get the information up to you in a uniform fashion so that you can do what you need to do to manage the judicial branch of government. So we're working on that piece. And if there are no other questions, I'll say thank you very much.
Judge Krieger,
and take my pen and paper back to the place where I have my iPad.
Judge Krieger, we want to thank you for your leadership of the commission and your diligent work on these very complicated issues. Thank you.
It's my pleasure. It's been a fascinating journey.
And I add thanks to all who participated here today. We appreciate the participation of everyone and your contribution to this process. Thank you very much. We now will move to the third case on today's. Okay. Actually, we're going to, after a 10-minute recess, move to the third case on today's docket. But the court will now stand in recess for 10 minutes.
All right.
We will now consider the third case on the docket, Butler versus the State of Florida.
Good morning, may it please the court. I'm Mark Gruber with CCRC, and I'm representing Mr. Butler. There are a number of significant problems with the defense presentation in this case in both the guilt and the penalty phases. I'd like to come back to the penalty phase, but I'd say right now that it's really
Would you start with the penalty phase, because that's the one that seems to me, I'm not going to discourage you on the guilt, but
yes.
You know, I'm not, I don't see those claims as strong. But in the penalty phase, what's your strongest argument about why there's deficient performance?
Well, with regard to the first deficiency prong of Strickland, to state the facts of what was actually presented by Ms. Borghetti, who was the one who called the witnesses and presented the penalty phase defense. They called Junior Butler, who was the defendant's father, and I have an excerpt from his testimony after he had said some truly skeletal statements about the defendant's family background. He didn't remember how many children that he himself had. He didn't remember the name of the defendant's mother at first.
Well, what did the defense lawyer say about, did she meet with him and go over what his testimony would be and remind him how many children he had?
Well, the problem with what happened with the evidentiary hearing, of course, is that she said many things like she didn't remember. She said that she did have communication with him. What both the attorneys said is that they had these other witnesses that they intended to call, and they thought they would be the better witnesses to present the penalty phase, and then the witnesses didn't show up.
Now, of any of those witnesses that didn't show up, did you present any of those witnesses at the penalty phase, I mean, at the evidentiary hearing to say they would have shown up, or do we have any of those witnesses?
We presented, we talked to anyone who was still available to talk. We presented the great aunt and
I know
Aunt
who you
Brooke
presented. Were those two of the ones that they were going to present?
No.
Okay, so that's what I
that.
asked you. So you didn't use or didn't locate, or they were still uncooperative, any of the other witnesses. So isn't the argument that even if they had subpoenaed them, it's not a good idea to go with uncooperative mitigating witnesses?
Well, let me also point out that that Mr. Watts said that he changed his practice, and Ann Borghetti said yes. In any case, since then, we certainly would subpoena witnesses.
Do we even know who those witnesses were that they thought were going to come to court and did not come to court? Do you know who those witnesses are?
Off the top of my head, I don't have their names down.
But it is someplace in the record. And did you attempt to get in touch with those same witnesses?
Our office contacted every one of those witnesses, everybody who was of any. We had a mitigation expert who did a very thorough family background check and testified at length. And
I understand that, but I want to know, what did these witnesses say to you, the same ones who did not show up at the penalty phase? What did they say to your office when you attempted to contact them for the evidentiary hearing?
Okay,
I mean, if they were uncooperative then and they're now still uncooperative, how was the defense attorney? Explain to me how the defense attorney is defective because these people ended up being uncooperative.
Well, the testimony from the defense attorneys on this point, although they did give a list of specific names, although she did list, she did say what these people were. Beyond that, there were no time records. There were no any kind of documentation about when she talked to them, if she talked to them. A lot of these witnesses were names that were actually located by the public defender's office, and they represented the defendant, and they started working up the background mitigation while the case was being prepared, and then they withdrew in a conflict of interest, and Mr. Watts and Ms. Borghetti were the trial attorneys. They came in. So they're referring, and what's being brought in by the state during the evidentiary hearing, are various documents that are actually in the court file. Now, when the defense, when Borghetti and Watts are being asked about them, they're saying over and over again during the evidentiary they don't have any specific memory of.
I think you're missing the question. It's a very fundamental question. Did you present evidence during the evidentiary hearing as to what evidence would have been put on by these people, either through a mitigation expert or the witnesses themselves?
What?
It's a very simple, very simple, direct, so that we can find what they would have said had they been called. I mean, that's.
Mm-hmm. I'm sorry, but I'm thinking now we did not hash it out as to those specific witnesses as to what they said. I don't know if that's actually in the briefing now or not. What we did do is present through the witnesses that we thought best for our own independent background.
You're saying other persons.
We presented what we thought was mitigating
evidence. Let me try
evidence.
to focus you even more. Let's assume deficiency. What I want you to do is, because clearly Junior Butler was a disaster, and the defense lawyer said so. She said the other lawyer was like throwing a pen at her, and I've had those experiences in my trial life. I go, oh no. But that doesn't mean I didn't do a good job. It just means that someone didn't turn out to be like I expected. And then the sister, that was a horrible disaster, that she had a dream and she dreamt that so that testimony was a disaster, but the defense lawyer recognized that. Now let's assume that it was a result of her deficient performance.
Mm-hmm.
Where is, it's a one aggravator case, but as the majority of the court found, it's a horrendous aggravator, and now we go to the mitigation. The judge didn't find in the original sentencing order the mitigation of Butler having a troubled childhood, and you've clearly put on evidence of a troubled childhood. But I think the one that would be the most important would be the mental mitigation. Did you have experts in this go-around to focus on the mental state that would have led him to commit this horrendous act?
Well, as far as any kind of nexus with the act itself, no, we didn't do that. As far as mental mitigation, the sense of anything other than his intellectual functioning, we also did not present any evidence of
why
of,
should
say, of
our
mental health.
confidence in the outcome be undermined? Maybe you can just, because I know you got to help us, got to sort of crystallize what's so great now about the mitigation that wasn't there in the original trial.
Well, the mitigation that was presented during the course of the evidentiary hearing, as far as mental mitigation presented, was the intellectual disability.
Which is what? What's
it was not quantified in the form of an IQ. In fact, Mr. Butler actually did balk at taking an IQ test, but through additional testing, through Dr. Caddy, through expert testimony, through the school records that were obtained of his basically D's and F's and being socially promoted when he even did go to school, a comment by one of the teachers that he was, quote, slow, and so forth.
He didn't want to be, the testimony was he didn't want to be, have an IQ test because he was resisting being found to be mentally retarded?
Yes. He didn't want, well, yes. But that
so you didn't have one. You have no IQ test of his, correct?
To my knowledge, there's no IQ test in existence.
How old was he when he committed this crime?
He was in his early 30s.
So the idea that he's a slow learner in school, how is that going to mitigate? I understand it doesn't have a nexus, but from my point of view, to really undermine confidence, we've got to see compelling mitigation. So let's go. So you're saying you had the school, that he was, intellectually deficient. What else?
Well, we also have the formative year, the developmental, the background mitigation of the really squalid, really brutal conditions that he was in as he was raised essentially on a plantation in the child in this setting. Actually, the judge below commented on that it seemed like we were doing another installment of Gone with the Wind. He did say that. But that was a setting that we had for Harry Butler growing up. He really had no education to speak of. When he was administered these tests that Dr. Caddy was able to get him to take. He couldn't spell anything. It also, he's essentially illiterate. So that's as far as he got with school. He dropped out. With regard to being brought up, the setting that he was in, there was a chaotic family situation. Essentially, the husbands and fathers and roles and so forth are being changed almost on a daily basis. They had no money at all. They were outhouses. These were shacks. There were no real opportunities, and the individuals who were living in this circumstance were certainly given no hope, no structure. There were no positive role mothers. His brother died.
Dr. Mayer. Dr. Mayer was used in the Spencer hearing in the original case?
Yes.
Dr. Mayer said, my information's limited. It's based on one interview with Butler. It's not based on social service records or school records or other kinds of records of his childhood. Mm-hmm. Did the attorneys in the original case obtain the school records, social service records, and are those now, if they weren't obtained, are they now available, and did your experts use it to portray a very different picture of Mr. Butler?
Right there, the records that we obtained are all in the are in evidence in the evidentiary hearing. They were used by Dr. Caddy, and they were reviewed by Ms. Furtick, the
where did you
mitigation
get those
expert.
records? Are you saying there were none of those kind of records in the original attorney's files?
There were no school records, for example, from Georgia, but there were school records from St. Pete.
But then they didn't give them to Dr. Mayer?
No, Dr. Mayer said that he was provided with this interview with Mr. Butler that was very short, and then a hypothetical outline of some facts that he was being asked to consider.
Did you ask the attorneys why, again, you've got a one aggravator case, and, you've got somebody that clearly had a troubled childhood, why they didn't develop and again, putting on this father, mm-hmm. I have a hard time understanding how, even if you had nobody, you would put on the father under those circumstances. Why they didn't develop the mental mitigation? Or the whole picture? Was that asked, why Dr. Mayer was given such a skeletal bit of information? Because that concerns me as, in this case, well, you say, oh, they hired a mental health expert, but it sounds like they didn't do much with him.
Well, they had, earlier in the case, they had apparently consulted with a Dr. Fireman who was someone who did this type of psychological mitigation fairly routinely there. But the only thing that they had from their files, and the only thing that they recalled about it, was that Dr. Fireman was not especially helpful. What was introduced by the state at the evidentiary hearing was some correspondence showing that the two of them had conversed. And that's all we know. We don't have any indication from the defense attorneys that they went any further with Dr. Fireman. Dr. Fireman did see Mr. Butler.
Well, so what do you have now? I'm not minimizing the troubled childhood, but again, tell me what you then have about what you would say should have been presented in terms of his mental disability or illness or intellectual functioning. What doctor or expert testified to that at the evidentiary hearing?
Well, what we have is Dr. Caddy testifying to the intellectual deficits as well as he could in the way that I described it. And then what we also presented at length was a description of the defendant's background and the things that I've gone through. And I have a line at the end of the reply brief that it's evidence of the family background and personal history, substance abuse, being raised in a chaotic family circumstances. There's no parenting. So his older brother, one older brother died, the other one went to prison. There was violence that was carried out before him, and those are all mitigating circumstances.
Yeah, I know, but then you got the judge saying on page 25 of his order, he took all that into account and says, well, Mayer was retained only after Fireman evaluated Butler and made findings that were not beneficial. And it says, although there's now extensive testimony, the essence of the testimony amount of things already heard. They grew up poor. His mother and grandmother died when he was young. And not that he's minimizing, but he says that none of this additional testimonies was of such significance that had it been presented, it would have persuaded the jury to recommend life or the court to ultimately impose a life sentence. So he's sort of saying, let's take all of this childhood.
Mm-hmm.
It still doesn't undermine confidence in the outcome.
Well, and that's true. That is what the lower court decided, and we're arguing that there's prejudice in an ineffective assistance of counsel setting where you look at the actual information that was presented to the court at the time of the penalty phase, and as you're saying, it's deficient, or assuming that it's deficient. I'm going further and say that we said there that it actually made things worse. I mean, the jury
well, I think that's an important
this.
point that I'd like, that is, it would almost have been better for him to present nothing than to have presented the witnesses they presented.
In particular, Mr. Watts said that they were, to some extent, pursuing a residual doubt or a lingering doubt theory, and then having the sister come in and say, well, the Lord had told her the night before that he was guilty, obviously didn't help their strategy very much.
Mr. Gruber, I know you're into your rebuttal time, but you have a lot of evidentiary issues in this case that you think that the trial judge or trial attorney was faulty in. And would you tell us which of these is your best issue? Because this is not a case where there, in my estimation, where there's a lot of evidence that really connects Mr. Butler to this case. So what do you think of all these evidentiary errors that you propose would have made a significant difference had it been done differently?
Thank you. By far, it's our argument 5 that there's a bloody print on the phone. I really did want to get this point out that with the order from the judge saying this is a palm print, and so forth, it's not. That's not what Carol Davis said. She said there's a print, it's on the phone, it's she cannot say from what part of the hand that it came from, and it was the state's argument, it was the state's theory that it came from the palm.
But she didn't say that this was probably a palm print? I thought I read that multiple times somewhere here, that this was probably a palm print.
I agree with exactly the words that you're using. To a reasonable degree of scientific certainty, there is a print. There is not a reasonable degree of scientific certainty to say with that certainty that it is a palm print as opposed to a finger.
Let's get cut to the chase here. Okay. Assuming that there was a print, whether it's a palm print or a fingerprint, and that it does not fit the victim, the defendant, the child, or other people who would have logically been in the house, where does that get you?
It's in blood. It was deposited there at or very shortly after the time of the offense, and it points to a person as yet unknown. And one thing that's kind of unique about this case is that's exactly the mistake that defense counsel made rather dramatically in opening statement, saying that there's DNA here. It points to a person who is as yet unknown, and that's the killer.
You're talking about the sliding glass door thing now, right?
Yes, yeah.
Okay.
And then, of course, they had to walk that back because it was incorrect. And in the meantime, here's all this evidence that's actually there, and they just
your
didn't get it.
argument is if the jury had heard about this bloody palm or fingerprint, and that we don't know whose it is, that it was not the defendants, could have been the victims, that would have made them decide Mr. Butler was not the perpetrator.
Yeah, that kind of evidence is really dramatic. Of course, talking about reasonable doubt. Another point I did want to make about that, though, is that the reason that the state's theory is that it's a palm print and remains speculation is, of course, that the victim's remains were cremated, and the police, when they took these prints, did not obtain what they call major case prints that they're saying now would have been done, and they changed their policy as a result of this case, that they now obtain major case prints. So,
which means that they take something of the whole hand, or is that what that means?
As I understand it, whatever prints there are on the human hand are going to be in those major case prints. That was not the case with the prints taken here. The police didn't do the investigation in order to address that issue. And again, that's the type of evidence that would have a great impact at a trial where the jury's considering lack of
the
evidence.
fingerprint expert in this case, what is her name? Carol Buchamp?
I call her Beauchamp. She's Carol Davis.
She was not even deposed by defense counsel.
Right, and she was called by defense counsel, too.
Excuse me?
She was called by defense counsel.
She was called at trial, but prior to, she was never deposed, and I don't know, according to trial counsel's testimony, he says he was probably aware that there may have been a palm print there. It didn't belong to his client or anyone in the house, but didn't think much of it. I mean, it sounds to me like this is a major issue that points to reasonable doubt.
Oh, no. What defense counsel said was very clear with regard to this. We talked to him beforehand. He knew about what he said was that correctly, that as a discovery process, they had the photograph, they had the raw information about this print in their file. So he was on notice about it, but he simply missed it and did not realize its significance. He said that in the evidentiary, and that if he had known it, he would have used it.
As a defense lawyer, how simple it is to get before a jury and tell them, ladies and gentlemen, there's a palm print there with a fingerprint that doesn't belong to anyone in the house and my client. And that there tells you who did it. This is who killed this person. Because this was a whodunit type of defense, wasn't it? It wasn't like you weren't claiming anything else.
Yeah, we might. The palm print, it wasn't a palm print. There's evidence of from the shape of a palm print, DNA evidence, and that's what the defense counsel was talking about. That evidence turned out to be a misreading of the record. What I'm saying is that it's kind of ironic that at the same time there was a print on the phone that was found inches from the victim's body that was in blood. And it was that print that defense counsel had the data, had the photograph of it actually, and by his own admission, he missed it. He just did not know to bring that before the jury. And then defense counsel in closing argument is forced to walk back what they were saying about that palm print.
Counsel, you have more than exhausted all your time. I will give you a minute for rebuttal.
All right, thank you.
May it please this honorable court. Your honors, my name is Catherine Blanco with the Attorney General's office. I apologize for my voice. I'm afraid I'm fighting a cold here this morning, and I hope the court can hear me.
And may clarify the confusion I'm having with this palm print and this fingerprint.
Your honors, I would direct this court's attention to the post-conviction record, volume 5, at page 728, 743, 752, and 753, where Carol Davis Beauchamp, the examiner, testified that it appeared to be a partial palm print, and the specific area was the area between the index finger and the thumb.
So there was a partial palm print in blood.
In blood.
And where was it located in the house?
It was on the telephone, on the telephone receiver. There was testimony at trial that all the blood that was tested from the victim's apartment all came back to the victim.
But that particular palm print, didn't she testify that that she ruled out any occupants of the house and the defendant as being?
Exactly. She compared it to Harry Butler, Leslie Fleming, who's also known as Bay, the victim, Martisha Kelly, Dennis Tennell, Ronald Corker, Adonis Hartsfield, Shauna Fleming, Stephen Shine, who is the boyfriend of the sister, Shauna Fleming, and LaShara and other juveniles. Yes, those, she was never able to link that print to any of them. She was unable to rule out the victim, Leslie Fleming, because the victim had been cremated and they did not have that portion of her prints.
So there was an argument, at least, that the print may have been left there by a third person who may have been the killer. I mean, that's an argument that the defense could have made.
Very weak, Your Honor, in light of the fact that you cannot rule out the victim. And Leslie Fleming, when she was discovered, the phone was near her body. LaShara picked up the phone and gave it to Shauna, who is her sister, Shauna Fleming, who actually made the phone call. And Shauna and LaShara are eliminated, and the only one we cannot eliminate of those occupants at that time is the victim. And given the proximity of the phone and the blood, all of the blood coming back to the victim at the scene. No DNA blood evidence linked Harry Butler, and the jury knew this at the time of trial.
So what is the, in terms of his guilt, what are the essential parts of the state's case? And if you want to focus, how much did the child victim, how important was her testimony?
Certainly was important, Your Honor. You have the threats that are made by Harry Butler before the murder that he's going to kill Bay and Red. Bay is the victim's nickname. Red is the nickname for Lakeisha Miller, who happens to be Harry Butler's cousin, and he felt that Red was causing the both Bay and Harry Butler the conflict in their relationship.
Well, he was, I mean, again, he was, and I understand that kind of statement, and we don't have a domestic violence exception, but this was it wasn't his wife, but they had how many children together?
They had 3 children together, Your Honor. Bay was 23 years old when she was killed. Harry Butler was 36. They had been together since Bay was a teenager. Leslie Fleming, I should call her. I apologize for just using her name.
He was upset because she was now having an affair with somebody else.
Adonis Hartsfield, who was, by the way, excluded from the phone print as well.
And that would be that was his motive, according to the state, for the murder.
Well, the state's theory at trial certainly, although obviously you don't have to prove motive, was given the circumstances of Bay having him put out of the house, as Shauna testified on March 9th, that it had been a very fractured relationship, but she had taken him back in the past. On the 11th, Harry Butler is arrested for domestic violence against Leslie Fleming. The officers, when they get to the scene, she appears to have been crying. She has marks on her arm and on her back, and he is taken to jail, and he bonds out the next night. And that's when he makes the statements regarding the kill Bay and Red. In addition, you have at that point in time, you also have Harry Butler being seen in the proximity the night that Bay was killed. She was killed. It was believed to be before 4 a.m. on the morning of March 14th. You have Lola Young, who's outside her home. Their apartments are fairly close together. She happens to be outside going to the dumpster between 3:30 and 4:30 in the morning. She sees a man that she identifies as Harry Butler. She knows Harry Butler. She recognizes the voice. Harry Butler is outside Leslie Fleming's home at that point in time. With regard to LaShara was 6 years old at the time of the murder. She testifies, and she is picked up out of her mother's bed. She's sleeping in her mother's bed. She's picked up by her father. She sees his face. She knows it's her father. She then testifies that she hears her mother say, "Stop, stop," and she saw her father's leg and her mother's leg entwined, and then she goes back to sleep. And that morning is when Shauna Fleming, who is Leslie's sister, is knocking on the door at 7:30 in the morning, and LaShara walks past her mother's body to open the door to the home. Immediately after that, you have the defendant disposing of incriminating evidence against him. That would be his T-shirt, his shorts, his underwear, his shoes. Apparently, when he was at the motel where he was staying, a lot of drug activity at the hotel. People are coming in and out, and there's testimony about washing.
Excuse me just a moment. But in regards to all those items of evidence that you just talked about, his shorts and his shirt and all, there was no blood on those, was it?
There were. They were unable to get any DNA. The items were wet. Either they had been washed or because they had been deposited in this dumpster. It had been raining. And so you have both testimony with regard to the shower running and also that it had been raining. And you have the items that are recovered, a T-shirt that matches the defendant's size, could have been identical packet. And in fact, when Mr. Butler testifies at trial, the prosecutor inquires about this. He said, hey, you've got a 34-36 Fruit of the Loom V-neck. It's identical to this shirt out of the dumpster. And he said, looks like it came out of the same package. And he said, well, it could have been. There was trace results on there, but inability to obtain any DNA, which essentially whatever it was degraded and could not have been identified at that point in time. You also have the shoes. The shoes are an issue in issue 1 of the defendant's brief. The shoes that Harry Butler admitted were his shoes. There were videotapes showing him wearing these particular shoes, but when he is arrested, he actually has Dennis Tennell's shoes.
And he says Tennell actually borrowed those shoes from him.
Well, that's Mr. Butler's testimony. Mr. Butler's testimony wasn't me. Take a look at Dennis Tennell, maybe Adonis Hartsfield. You have both Hartsfield and Tennell, nothing on the shoes linking Adonis Hartsfield to those shoes, nothing linking Dennis Tennell to those shoes. So that is really actually undermined in post-conviction. And of course, again, the place where you find this evidence, where it has been discarded and
where was it? Where was this dumpster?
It was excuse me, Your Honor. It was a dumpster that was close to a convenience store that was near Harry's apartment. When Tennell and Mr. Butler are walking back to the apartment, they take 2 separate routes. Mr. Butler's on the road. Tennell's on what's called the Pinellas Trail, which you're not supposed to be on at night. In any event, when they're walking back, Butler takes the route passing by the convenience store where the dumpster is. They're midway down, covered with food, maggots, water, highly contaminated site. But again, in post-conviction, that's one of the issues. Mr. Gruber hasn't discussed that this morning, so I'll be happy to answer any questions, but it would probably not be fair to address that any more than that with respect to that point. If there are no further questions about the partial palm print on the phone, Your Honor, I believe that I would like to address issue 9 of the defendant's brief, which is the claim of ineffective assistance of penalty phase counsel.
Let me ask you on that.
Yes, Your Honor.
As you know, the opinion of this court was a 4-3 on whether the one aggravator was sufficient, and there was really no mitigation presented. It sounds now, as we look at this, that my view would be it was worse than no mitigation, because Junior Butler was not only not a sympathetic character, but why would you call him, but more of concern about what was going on with these defense lawyers, or particularly the one that presented, is that apparently the sister had a dream the night before. Now, the prosecutor knew she had a dream because it comes out on cross-examination. Did the defense lawyer not know she had this dream? And why wouldn't she have moved in limine to prevent that testimony? And what I've got is that, let me just make sure I can see this, is that not only, so that during cross-examination it came out that the prosecutor met with her and that morning and told him that God told her who did the crime, and it was her brother. There was no objection or redirect examination. So to me, it's not only that you put somebody on, but you put someone on that had this critical piece of evidence that shouldn't have come out. And then when it comes out, you do nothing to say there's got to be about it. So tell me what the situation is, because on its face, that looks like, what were you doing, Miss Defense Lawyer? And she hadn't ever had dealt with a death case before.
Yes, Your Honor. To answer your question with regard to the Sandra Brown testimony, Sandra Brown is Mr. Butler's sister. That testimony did come out. Ms. Borghetti did not address it in post-conviction to the extent that she knew it or did not know that that was a possibility.
But do you agree that if she didn't know, that's deficient? And if
No.
she did know that it would be, she should have moved in limine?
No, I don't, Your Honor, and the reason I don't, and I don't mean for this to sound like a flip response, and it may come across that way, but you have the jury having already found the defendant guilty. So the witness who says, and God told me Harry did it, or words to that effect. And again, I knew that when you're looking at the comment, you say, okay, God told me Harry did it. And when Miss Sandra Butler takes the stand, she is crying. She has to regain her composure. She said she cried all night. She is obviously a person of faith. There is never any statement that, and Harry Butler, my brother, should get the death penalty for this.
What was it she offered in mitigation?
What she offered in mitigation, and I'll also address Junior because I know Your Honor is
Rambled
concerned
on
this.
about how he didn't kill his wife.
Sure.
In response to, so do you have anything else to tell the jury? And he rambles on, and that's the same thing. The whole thing is incredible to me as far as what was presented.
Well, you know,
bad from Mr. Butler.
Your Honor, Ann Burgetti
Could you say what the
testified.
sister did testify to? You were going to say.
Yes, I will. Thank you, Your Honor. Yes, with regard to what Sandra Butler testified to, she testified that her brother protected her when she was a child, that when their grandmother died, that Junior went to live with Mr. Butler, and that Sandra was still in Georgia, that she loved her brother, and that she was obviously very upset about this, and she had prayed, as we know, she had prayed to God. And then on, I think, 4 questions or whatever in the prosecutor's cross-examination about having just met Sandra that morning, and that what she had revealed to him.
That's a critical thing. How did he just meet her that morning? Did she just go up to the prosecutor and start talking to him about this dream or what she was told during the night, or how did that all come about?
Apparently what happened, Your Honor, or at least according to the trial record, is the prosecutor said, Ms. Butler, we just met this morning, you shook my hand, and you told me that you had a dream. So apparently they were in the hallway or outside the courtroom, not in the presence or in front of the jury or anything like that, and she approached him and introduced herself and told him that she had had that dream. And again, there was no argument from any witness in this case presented by the defense. And by the way, the defense presented 21 witnesses during the guilt phase. So this is not a case that was not hotly contested and investigated. But in any event, they did present 21 witnesses at the guilt phase, some of whom carried over to the penalty phase. And so with regard to Sandra Butler's testimony, her testimony was impassioned and obviously...
But she was asked no questions about how they grew up and what kind of situation Mr. Butler lived in. I mean, because the way defense attorney paints it is he lived in abject poverty on a plantation, I think he even said. And so, I mean, nothing was asked of her about that situation?
Sandra was asked about her upbringing, and there was an attempt to show that it was a poor upbringing on a tobacco farm. With respect to that, however, Sandra and Harry Butler did not grow up in the same household at that point in time. Harry Butler's mother was killed when he was, or drowned when he was 3 years old. And so,
what was
he
the reason
eventually...
for calling her? Was she just down there because she had been there for the guilt phase? Did she live down here?
No, actually, no, she was called. Justice Perianti, you had a question earlier about who Ms. Borghetti spoke to, and so if I can go ahead and address that while we're on this train. The witnesses that she spoke to as possible witnesses for the penalty phase, that include Colleen Ryan, Leroy Bell, Orrin Pelham, Robin Green, who was the mother of Butler's 3 older children. Harry Butler has 6 children altogether. James Wood, who's the defendant's employer, Junior, the defendant's father, and the defendant's siblings, both Sandra Butler and Terry Butler. And this appears in the post-conviction record of Volume 8, 312 through 313. So the defense... the question was raised by Justice Quince, well, what of those witnesses did the defense hope to present at the penalty phase that weren't presented? And Mr. Watts in post-conviction responds that the two witnesses that they had hoped to present were Robin Green and Harry Butler, Jr., the defendant's oldest son by Robin, or oldest child by Robin. Now, neither one of those witnesses was called in post-conviction by CCR, so the question was, well then, you cannot establish any prejudice for failure to call those particular witnesses. In addition, there were allegations or apparently instances of domestic violence involving Harry Butler and Robin, and obviously CCR made a decision not to call Robin in post-conviction and not to call Harry Jr. in post-conviction and not to call any of the other witnesses that the defense at the time of trial had investigated. What they do present in post-conviction are a distant relative and who did not know the defendant as a child. Harry Butler, until he was 10 years old, lived with his grandmother, Hattie Mae, after his mother died. And by all accounts, his account anyway to Dr. Caddy was that he was a happy-go-lucky kid. Now, this stands in contrast to the portrayal that the defense post-conviction expert, Ms. Furtick, attempts to portray.
Well,
or
what did she
tries to
base
portray.
her testimony on?
Ms. Furtick says she went to the location where the defendant's mother was buried. She looked at the family, the tobacco farm where they grew up. She reviewed records, school records, and people around the time that had allegations at least that Hattie Mae was beloved, but her husband was a harsh disciplinarian. That Junior Butler was accused of running around on women. Also that allegations from Annie Brookins. Now these are, Ms. Brookins' testimony is actually direct, and that involves her relationship with Junior Butler. But when Ms. Brookins was involved with Junior Butler, who was the defendant's father, and there was domestic violence, the defendant was in Georgia. He wasn't living with Ms. Brookins and Junior at the time of these incidents. So it's remote as to other family members. The defendant testified at trial, and he testified at length, and he gave a really fact-specific and lengthy chronology of his events on the night of the 13th, the morning of the 14th. He's got a timetable. He's identifying witnesses. He's saying who he was with. He's saying where he went, when he went back, his mode of transportation. And he, again, is placing the blame on Dennis Tunnell as the perpetrator of the crime or a likely suspect for the crime. And, again, nothing in post-conviction supported that in post-conviction or at the time of trial. The penalty phase witnesses that were called did establish that the defendant grew up in, the family was poor. That came out from Junior Butler's testimony. The family was poor, that the defendant's mother had died when he was a child, that the defendant was raised by his maternal grandmother until he was 10 when she died, and then the defendant was brought down to Largo to live with his father. The defendant's family tree was done even at the time of the trial to try and present a picture. It did not go as the defense has planned. The defense recognized that in post-conviction. But as the trial court's lengthy order explains, the defendant failed to establish both deficiency and resulting prejudice, and even if they could establish a deficiency, there is no resulting prejudice in light of the amplification of the testimony that was previously presented in at the trial, and ask this court to affirm the trial court's order denying post-conviction relief. Thank you.
Defense counsel said that he believed there was a domestic violence exception to the death penalty and that this case would be reversed and remanded for a life sentence by this court on direct appeal. That's on the record as part of the evidentiary hearing. The print that we're talking about is also introduced by us. It's on the record in the evidentiary hearing, and I am arguing it sure looks like a finger. And if it is a finger, then it's a third party. It's not the victim.
Well, I mean, what's the evidence, though? I mean, I understand your view as a litigant. What's the evidence from the folks during the trial? Are you refuting or in some way suggesting that there's no evidence that this was a palm print?
That this was, I'm sorry.
You say it's a fingerprint. I understand that. You're an advocate. What's the evidence?
Okay, from the trial itself, this was, I don't even know if it was introduced at all. I don't think it was. It was completely missed by the defense, and the state was staying away from it.
So there's no evidence that this was a palm print from the examiner, and that she excluded everyone but could not exclude the victim. That's not part of the evidence in the underlying case?
Well, that is what she said, yes.
Okay, but then now you're standing up saying it's a fingerprint. So I'm trying to see what's that based on. Is there evidence that that was a fingerprint?
What I'm saying is that what the fingerprint Carol Davis said is that within her scope of expertise, she could say that that was a print and that it had enough characteristics for identification if you found a known one to compare it to. What she could not say to that degree of certainty was what part of the hand it came from. She said, in her opinion, that it looked more like the part of the palm. Okay. We're saying it looks more like a finger.
Did you have anyone who testified that it was a fingerprint and not the palm print?
No, we got our own expert to say exactly what I just said right now. You cannot get an expert out there to say that.
Say exactly. What did you just say?
Right, that you cannot get an expert to say whether it is a finger or whether it is a palm, just based on looking at the print. Okay.
With regard to the penalty phase and the sister saying, God told me last night that my brother did it, is there evidence that you put on during the evidentiary hearing that the defense lawyers knew that this is what was going to come out during her testimony?
Oh, they didn't.
They did not. So it was a shock to them.
They were shocked by it.
Okay. And did they meet her that morning? Is there any evidence with regard to meeting with that witness or talking with her or?
Whatever it was extremely vague, and it was tinged by lack of memory, but they did have some meeting with her of some sort.
And was there any evidence with regard to performance of lawyers when a witness starts talking about religion and God, about standards of how you deal with that as a trial lawyer, whether you are supposed to head-on attack, cross-examination, because religion is a very delicate issue. And how is there evidence in the evidentiary hearing that it's below standards to not attack a witness who says, God talked to me last night?
It certainly was during argument. We did present a Professor Dow who talked about the ABA guidelines.
I know that. Did he address cross-examination of a witness who is, it appears, is a very religious person and not pseudo-religious? It has a very spiritual background. Was there evidence of how lawyers are supposed to deal with that?
There was and has been argument from me. What the lawyers did was they were in shock. They sat down. Mr. Schwartzberg, despite having told the jury that he wasn't going to participate in the penalty phase, jumped in and gave an impassioned plea. Why the lawyers did not present any evidence during the Spencer hearing and things didn't go well before the jury,
That's not what I asked.
They were asked. They didn't do that.
I was asking you about the principles of cross-examination and whether it's deficient to not attack a witness who's spiritual and testifies about something of a religious nature. That's my question.
They should have done something to deal with it.
But there's no evidence from another lawyer, from an expert on that? That's your personal view?
I'm worried that what happened was their star defense witness came up with this total shocking claim about a dream.
But you said you're criticizing because you didn't cross and attack her on cross-examination. I'm asking you whether there's any evidence of how, it's a very simple question. Maybe there's no evidence, so.
Yes, I'm saying I don't think the religion aspect has much to do with it. It has to do with a bad defense presentation and penalty phase. But thank you.
We thank you both. We now move to the fourth case on the docket today, Peterson versus the state of Florida.
Crazy.
May it please the court. My name is Dave Davis, representing Mr. Robert Earl Peterson in this capital case. Case arises out of a murder that occurred in August 2005, in which the state eventually will charge Mr. Peterson with first-degree murder and destruction of evidence. The jury will eventually, he'll be found guilty, and the jury will eventually recommend by a vote of 7-5 that he be sentenced to death, which the court does, finding 3 aggravators and then several items of mitigation, which it did not give much weight to. The facts as presented by the state are that in August of 2005, Robert Peterson was 40-year-old, living with his parents, or rather living with his mother and stepfather, Roy Andrews. His mother would on occasion and regularly give him money, and in the preceding year it's estimated about $25,000.
Is there any I saw something in the record that might indicate that the mother was involved in getting him to kill stepfather. Was that ever pursued?
No.
It's a letter that he wrote to his mother while he was in prison that seemed to imply, hey, you're supposed to back me up on this. So I just wondered if anyone tried to say that the money that he was getting was in anticipation of...
No, that was, not at all. The money was basically given for things like child support, and he was going to do some carpentry work on a next door house and things like this. Well, by August, or really July of 2005, Roy Andrews, the stepfather, had enough of this, and in a tough love sort of approach says, you're out the door. And told Peterson to go find another place to live. Peterson, at least according to the state's evidence, was angry at this and threatened to kill Andrews. And he, in fact, did so, made that admission to Jimmy Jackson, who was a drug dealer, drug buddy of his, that, as developed in the defense case, that Peterson and Jackson had got together, that Peterson was going to give, in fact, had given Jackson $10,000 for some cocaine, and he was going to then turn it into $14,000 after he sold it. So in any event, on the morning of the murder, which is August 8th, 2005, some construction workers are at a shop near a cemetery in Jacksonville, heard 2 shots, saw a pickup truck, and then saw another pickup truck rapidly moving away.
I don't want to stop you, but you have, as I see it, only one point on appeal
guilt phase.
Regarding the guilt phase,
yes.
And that's not even a comment that was objected to. So could you...
Do you want me to get to that?
Well, I think you do. I mean,
okay.
I would assume you...
I'll be glad. I'm just
familiar with the facts.
Yeah, I just want to kind of bring you up to speed here on what's going on, the facts. Okay, what happens then is the defendant had filed a couple motions pre-trial to suppress those statements, basically on constitutional grounds. The court denies it. Before going to trial, the state had scrubbed what I'm talking about is the conversation that was recorded by the police. They had wired Jimmy Jackson, and then in a subsequent conversation, Peterson essentially admits killing his father, beating him up, and then shooting him.
So, when I first read that, the first thing that came to my mind was United States versus Henry. But that is a situation where you have to be in custody,
right.
Isn't it?
Right.
And the police then send someone in to surreptitiously question.
In a jail, typically in a jail situation.
So
Yes.
I just want to make sure
No, that's not here.
That's not what we have here.
No,
But we have to look at him as if he were an agent of the state.
Yes, I think he's clearly an agent of the state.
So
I mean,
but you don't raise. Well, you do have. I'm sorry, you do have the motion to suppress issue.
Yes.
Number issue 3.
Yeah, I do, but I really don't want to.
It's a strange issue to me because as I understand what you're saying is that even though he was not in police custody, and so this wasn't a situation that involves Henry, that before he could talk to this guy who was wired, he needed to have been given Miranda rights.
Your Honor, can I just rest on my brief on that one? I understand where you're coming from. Let me just, because I don't mean to really kind of.
No, we appreciate that, and we'll definitely let you do that.
Because I think it's an important issue, but I think the brief adequately. But I think the more significant issue is the statements that the jury heard. And that the
possible another murder.
Yes, that's.
But Mr. Davis, my problem with that is that you just said that the state scrubbed the statement to make sure that they put anything out of it that had to do with an implication that he killed his girlfriend.
There was clearly some damning stuff.
I don't want to. The defense lawyer had a chance to object to it and didn't see it as you're seeing it, which is that stack them double meant that he had also killed his girlfriend, as opposed to admitting a location where he then killed his stepfather. And there's something poetic, I guess, you're going to put your stepfather in the same the grave of your girlfriend. But if it doesn't, I mean, it wasn't objected to, you agree with that, so it would have to reach down to the whole validity of the verdict to be fundamental error. So first you have, it can be maybe it could have your interpretation, but maybe it's just the location. 2, that it's intertwined with where he's explaining that it is. 3 is that you got the rest of what he tells Jackson, which is, I killed him, and he had a motive, and he had told other people he was going to beat his stepfather to death, and all these things you said about his truck, taking the truck. How does that one statement that can be construed both ways amount to, fundamental error that we should reverse the whole
Understand.
guilt phase?
I think I understand. What if I can rephrase your question is, how does this statement, can we infer that defendant admitted committing another criminal
No,
act?
let's assume that you can infer it that way. How is it still that alone when it's, first of all, intertwined with the location, and then all the other evidence meet the standard of fundamental error?
Well, what it does, it's more than just simply, I landed it on a grave. He says, I put one top of I ain't got problem doing it. I'm cold-hearted. So it's clearly, I think, an implication that he had killed her. Now, it was not objected to. I agree with that. Now, does it become fundamental error?
Did they argue it in closing that he had killed his girlfriend?
No.
How did they use the stack them double?
Well, the prosecutor does, because to show the location. I mean, they bring through several witnesses, the aunt, the cemetery manager, that yes, Cheryl Guerrero was buried there. But then they also play the stack them double statement during the as part of the overall statement that he made to Jimmy Jackson. Then at closing argument, they bring it up again. And not only bring it up, that the initial closing argument, they play that statement again. I stacked them double. I'm just as mean as anybody.
Let me ask you this. Say you have a defendant who made an admission. When asked the question, did you kill John? He said that, and then the defendant says, that's the second person I've killed. Now, why wouldn't that statement just be admissible?
Because it's evidence of a prior crime, and it's just almost black letter law.
But it is intertwined with.
Well,
it's an admission against interest, but it is intertwined with the admission, and really inextricable from the admission of the particular crime, if that happens.
So why are we convicting the defendant? Because he killed John, or because he may have killed John?
I'm not saying they convict him of anything, but why is that not relevant evidence?
Because
highly probative evidence.
Because that second, the first, I'm assuming it's the first murder, has nothing to do with the murder of John. It has simply to go to this defendant's criminal propensities, and that is inadmissible, and that's what you said.
See, what would happen at trial, the statement is made, or going to be made, the defense lawyer says, wait, that implies because it's not even that he killed his girlfriend. At that point then, the state says, but it's probative. It's probative because it shows location. But at that point then, we do a balancing test. We look at whether the probative value is outweighed by the prejudicial impact. By the defense attorney not objecting, not only doesn't he recognize that it has the same sinister implication that you do, but it doesn't even give the judge a chance to do the weighing. And that's why I might agree with you if it had been objected to, and I'd hear what everyone said about why it was relevant, and then look at the weighing process. But when the state has tried, and this is not where the state's took out the things that implied what had happened, and you also have the statement right before where he talks about her having walked into the street and then been run over, so we have to put it in context. How can, it's not only not fault the trial judge, but how could it rise to the level of fundamental error?
Well, that's the real problem, isn't it? Because
It's
he
your
did
real
not,
problem, yeah.
he did not object to it.
Yes,
Now,
that's a real problem.
And so what happens here then is when you start looking the way the prosecutor used this, it was, if he'd simply used, I mean, he could have excised out further the fact that that stacked him double, because there was other evidence that was clearly that this was this murder.
He could have done it if somebody had asked him to do it.
All right, well, that's the idea of fundamental error, is the idea he didn't do it, and because he didn't do it, that was the error. Now, it's an error. Obviously, it'd been nice if he'd objected, nice if the court could have done it, but he doesn't. So, but the argument here is it's fundamental error, because it implies, it raises the specter that this defendant not only may have killed his father, but what makes it easier to find him killed his father is because he killed Cheryl Greer a year earlier. And that...
But in the context here where he's making this bragging about how he has killed his stepfather, the notion that that little fragment was somehow necessary to get this conviction seems to me to be fanciful.
Well, it really would. It would. But if the prosecutor then plays it again and again and again, not only during the trial itself, but then during the closing, it plays that part, I stacked them double, and then during it argues it in its initial closing, its final closing. Then in the penalty phase, it brings it up again. Why, in the penalty phase of all places, do you need it?
There's a lot of redacting that's done to this statement, and from what I can understand, the prosecutor and the defense attorney got together and decided on what could be redacted. Do we have anything in this record that indicates that he wanted that part redacted and that the prosecutor said, no, we're going to keep that portion in?
I mean, no, it's clearly fundamental error. It's got to be fundamental error.
Well, okay, and see, what I have a problem with in saying that it must have implied, and the prosecutor must have thought that, and everyone else other than the defense lawyer, Peterson says in answer, they're talking about his girlfriend, or they call her an old lady. Yeah, well, oh, no, I guess it's another old lady. An old lady did hit her, but she tripped and fell in the effing highway, didn't she? And you know what? This man landed on her grave. Okay, I stacked them double. Damn, as Jackson says. And then it says, yeah, I put one on top of her. It's her grave, so it's his decision, and it points to his culpability, because that's where the victim is found, that he knew where his girlfriend's grave was. He picked the cemetery, and it was all part of this cold, calculated plan. I said, yeah, like, I ain't got a problem with doing it. I'm just as cold-hearted as the next FMF man. I mean, so it's, as was said, it's like a bragging not that he killed his girlfriend, but that he didn't even care. He put his stepfather, who had cared for him his whole life, killed him in cold blood, and then threw him on the grave of his girlfriend.
Well, that's, yeah, I see where you're going, but I think it's also reasonable to interpret that I killed Cheryl Greer, and I'm going to put another one right on top of her.
You know, I understand that's your interpretation, but I guess we go back to this. If we don't agree that that's the most reasonable interpretation, you lose. If we agree that's a reasonable interpretation, we got Justice Kennedy's comment that it still is part of what he was saying as far as the location. It would have been hard to excise. But even so, if it was brought to the judge's attention, the judge would then say, well, I'm going to limit it only that there's no implication he killed his girlfriend, and, do a curative instruction, a limiting instruction. That's why, although I understand there can be fundamental error in cases, this is a classic situation for me why that's not fair to the state, to the trial judge, and to the system.
Are you then suggesting the defense counsel sandbag this issue, that he hid it so that I can now bring it up and face you and talk to you about it?
No, what I'm suggesting is that defense lawyer, I don't know, didn't see it like you see it.
Well,
And you're, listen, admittedly, you're trained. You may say, it jumped out at me when I read it that that's what it was.
Well, why would if it was just to find the grave, why would the prosecutor then, not during the guilt phase, well, he did it during the guilt phase closing argument, but then penalty phase, we don't have to worry about guilt. We're now talking about penalty phase. Why would the prosecutor then play that statement again during the penalty phase, if not to raise the specter of another murder or another homicide of some sort?
Well, I mean, I think that the chief raised the fundamental point is that if the admission to the killing in this case contains within it some reference to another death, you cannot separate the two. I mean,
sure you can. You do it all the time.
I'm sorry you can't, because this says I stacked them double. If that's the only statement that's in here, when the question is, did you kill someone, I stacked them double, that's what you draw the inference from, that he did the killing here.
Well,
so I mean that's the intertwining to them, not just limited in my view to the location on the grave itself.
Well, all
because
right.
you can have situations where this is in a confession. I can see it happening over and over. Where in a confession, did you kill so and so? I killed two.
Well,
does that mean the confession doesn't come in?
Well, what it means is I killed two doesn't come in. Because,
well, that's what I'm saying. Then the confession doesn't come in.
Well, I mean, that statement, I mean...
if that's the only confession, then that's excluded.
Well, then playing the statement, they perhaps get a police officer to come in and they can massage the testimony where he says, I admitted committing one.
I'm saying that,
but I mean, when you've got this guy committing another crime, and not simply another crime, another homicide, that's prejudicial. That's presumptively prejudicial under this case.
Don't we have a case, I think I dissented in it, where he went along in a car, and then there is a statement at a certain point where he says how many people he killed. Does that ring a bell to either? It's just ringing a bell to me.
There's not simply one case. There seem to be a couple cases.
Well, where we upheld it.
Well, I can't remember the holding. I just remember the phrase, but I can't remember what you said. But what I'm saying is the prosecutor plays this thing throughout the trial. The location, oh, by the way, stacked them double. I'm as cold-hearted as the next person. Plays this again and again, not only during its guilt phase, closing argument, but the penalty phase. Why would it do this if the location was the issue?
Are you going to argue any other point?
Yes.
Could I ask a question? I mean, I'm concerned about the victim impact statement of the son.
Oh, would you like me to talk about that?
Well, yeah, my concern is, okay, so if I agree with you, what's the remedy? Does it require a new trial? Does it require a new penalty phase?
A new penalty phase.
Does it require one at all? What's the standard for reviewing it? Is this harmless error? I'm a defense lawyer, and you can kind of sense my feeling about the victim impact evidence to begin with. And this court and the Supreme Court, U.S. Supreme Court, have allowed this stuff in, but it's inherently inflammatory, it's damning, almost on its face, but you've said it's not. It just comes in just to let everybody know what the last statement is not victim impact evidence. This is asking the jury
I want
for something.
I want just punishment.
So where do we go from there? If we say it's bad,
you go back and give him a new sentencing phase before a new jury.
Automatically, per se?
Well, in this case, yes.
Was it objected to?
I don't believe so, no.
Well, then we have that's the whole problem. And, again, I'm looking, if a defense lawyer is working with, these are letters that are being written, and the defense lawyer isn't asking the judge to redact it, it is how can it be fundamental error to, if we have Wheeler, we've got other cases, lawyers have to object to this, and I agree with what Justice Lewis is saying. We have to, then we can look and say, no, you're going too far. You've got to limit victim impact evidence.
Does there come a limit to you just sitting back and saying?
Well, this one was, as I understood it, it was an add-on. It was not part of the letter.
Yeah,
so the defense lawyer couldn't, but then follow up with Justice Periente is, so what did he do?
As far as I know, defense lawyer didn't do anything.
Nothing.
Because defense lawyer, I have yet to see, frankly, in the capital case I've seen where defense lawyers does anything with victim impact. It's so damning.
Are you talking, we're referring to the victim's son's impact statement?
Wayne Andrews.
Wayne Andrews, when he
yes.
said this was senseless murder, this crime deserves punishment?
Just punishment, yes.
My understanding is, from reading is that there was no contemporaneous objection made, but later on, when he was done, he got up and said, I didn't want to interrupt. Let me object now.
I'm sorry.
So there was an objection later on.
Maybe not contemporary.
Wasn't there an instruction given also by the judge to that tracked the requirements of the law?
Yes.
And that
yes, there was. But
Actually, and I correct myself, the defense lawyer did object and moved for a mistrial, and then said the court actually gave a curative instruction and gave it the way the defense lawyer wanted it. So are we going to say that one statement, which is the last statement, is enough to constitute reversible error?
Well, by itself, probably not. But when we've got other penalty phase errors that unfortunately, again, were not objected to, where they presented victim impact evidence talking about Roy Andrews being well, there was an objection to him presenting evidence that he was a police officer. There was an objection to that. That comes in.
That was in the guilt phase.
No, that was penalty phase. Penalty phase that comes in. Well, they wanted to bring it in during guilt phase, but they brought it in during penalty phase that he was a retired officer and he retired apparently several years before the murder. And he also had been a paratrooper in the Army. And then the prosecutor brings this out and then plays on it as his closing argument. That Roy Andrews, after serving his country and everyone, he went to work for the sheriff's office, his chosen profession, responding, rushing, racing, running into places that everybody else was running away from, helping his community for 30 years. And then he says, and then he retires and he took up a different path as mental health counselor. No objection to that, but this court, as Justice Periente, you've said in Periente, and there's another case that you've said this clearly wrong use of victim impact evidence. But again, it's not objected to, but with the 7-5 death recommendation, are you going to, and it's, it's hard to say that it didn't have any impact.
Now that you talk about 7-5, this may be a good case for you to bring up to the U.S. Supreme Court, because we got 7-5, we have no prior violent felony aggravator, and we don't know what aggravators the jury found. So it seems to me you have a clear ring issue if the U.S. Supreme Court decides to take this case.
Your Honor, if you would join with me on the brief. I have tried for 30 years to get that court to listen to me, and
they don't listen to me either.
Well, I appreciate the thought, but this is...
Well, this is a strong one, in my view. I mean, I thought Butler was strong too,
the ring issue has been brought up by not simply me, but numerous defense lawyers.
But we haven't had, almost every other case has had a prior violent felony. And this is a 7-5, which is, Florida's unique in having
jury
not a unanimous verdict.
That's correct.
So this may, I wouldn't give up on this one.
Well, it's okay.
I mean, you may want to give up here, but I'm saying,
the one, I have a couple minutes left. I do want to talk about the pecuniary gain factor that he found. And the judge found that pecuniary gain aggravator based solely on based largely, it was the critical testimony in the court's order is, and I'll quote it here, it says, Laverne Rundell and Becky Price, those are both a cousin and an aunt of Peterson, both testified that Roy Andrews had told them that this life cycle was not going to go on and that he moved out of his house and he and his wife were going to terminate the flow of money to the defendant. The defendant at the guilt phase objected, at least as to Laverne Rundell saying that same as hearsay, and the court says, no, that's just to show he was angry at the defendant. And then the court then turns around and uses that very thing that was admitted just to show anger is now showing for the truth of the matter. And so that was clearly hearsay. This court has clearly said that hearsay...
Which one? That's as to Laverne
right.
Rundell?
And the other one, Becky Price, he did not object to that. But what I'm saying there by that time is it would have been just a useless gesture because the court had already let that evidence come in. So the fact that he had not objected to Becky Price really should not preclude this court from reviewing this issue.
Who testified? How do we know? Who established that they were paying $350 per month for child support and $25,000 in cash and $10,000 in cash approximately 1 month before the murder? Who testified to that?
I can't remember. I'm sorry, but there's really no question. I don't question it.
Did Laverne Rundell, was she cross-examined?
Yes. Oh, yes.
It's not a Crawford issue.
No. Well, well, in a sense, it is because what you said in Keene that if you can't have hearsay from a dead declarant to establish an aggravating factor, and that's what you've got here. You've got Roy Andrews saying that I'm not going to let my son continue with this. I'm going to kick him out of the house.
Is that is there any other independent evidence? So the only evidence of the pecuniary gain was the fact that he was being cut off? Was it, because I thought what was interesting, and you didn't argue it, is that he had the record establishes that there was a considerable amount of money still in the wallet. How much, do we know how much money was left?
$1,100.
How much?
$1,100.
So is there any argument that really shows, it's not, this isn't pecuniary gain in the ordinary sense.
Right.
This wasn't a robbery.
Right.
He wasn't taking his stepfather's money.
Right.
So it's the pecuniary gain that he was being cut off. And what you're saying is the more likely thing is that he was just mad at his stepfather.
Right.
And this was anger, not
right.
to kill him in order to then get his mother to give him money.
Right. That's as supported by Dr. Morton's testimony about the cocaine addiction and the impact of that is because of the threat of being cut off and the reality of being cut off, he then killed his father. Thank you very much. Appreciate listening to me.
May it please the court. Meredith Carbula, Assistant Attorney General for the appellee in this case. Justice Periente, I'd like to start, if I could, with and Justice Kennedy. I would like to start first with the pecuniary gain, because the defendant himself told Becky Price, volume 21 of the record, page 529 to 531. Peterson told Becky Price Andrews had thrown him out of the house and told his mother not to give him any more money. He was going to kill Roy Andrews. He wanted to kill him. 2 weeks later, Peterson, from his mouth to Becky Price, he was very upset. His mother wouldn't give him any money again because Andrews told her not to. Peterson said he was going to kill Andrews. Pecuniary gain. Direct evidence from the mouth of the defendant. I'm mad at my stepfather because he's influencing my mother not to give me any more money. The defendant admitted during his testimony at trial that he had gotten a significant amount of money from his mother, and it wouldn't surprise him if it was $25,000. And if you look in the record, there's numerous canceled checks. She would be writing checks to him for $200, $300, every 2, 3, 4 days, every month for about a year. She's writing him multiple checks for a lot of money. So there was no dispute that he was living off his mother. He's 41 years old at the time of the murder. He's living off his mother, and he's angry at Roy Andrews because he's telling her to stop it. It's time for a 41-year-old to stand on his own 2 feet. And so this is not hearsay. First of all, we don't know how Laverne Rundle knew that. She didn't say Roy Andrews told me. She was asked, I think in general, she was asked why was Peterson angry at Roy Andrews, and she said because he was cutting her, he was influencing his mom, he was cutting her off.
If it was, so you don't, it could have been, could it have been from the defendant?
It could have been from the defendant. It could have been from Roy Andrews. It could have been from Patricia because that's her sister and they were close.
Did the mother testify to the amount of money being given?
She testified only at the penalty phase, and my recollection is that she didn't specifically say an amount other than a $10,000 she gave him for.
But so doesn't, I guess this is helpful for you. Doesn't that establish additionally that the pecuniary gain?
Absolutely. She testified that she gave her son money and is continuing to give her son money. But yeah, she said a significant amount. I don't specifically recall whether she named $25,000 because she probably didn't know.
Well, it doesn't matter. If the motive is, it doesn't matter if it's $10,500 or whatever. We've seen pecuniary gain where they take $2 out of somebody's wallet. And should that bother me that if it was for pecuniary gain, that as opposed to just a revenge, like P.O., that his stepfather was kicking him out, that he left that kind of amount of money in the wallet? It wasn't a quick getaway, was it?
Easy explanation, Your Honor. It wasn't in his wallet. It was in his right front pants pocket. And the 2 gentlemen who were working nearby to the cemetery heard the 2 gunshots, pop, pop. And right after that, they heard the truck. The truck the defendant was driving, that was his girlfriend's truck, which he crushed after the murder, quickly run out of the cemetery. Now, he told Jimmy Jackson that he intended to beat him to death. And the only reason why he ended up shooting him twice was because Mr. Andrews wouldn't die from the beating, from the brass knuckles, and that he had intended to beat him to death and take him to another location. So the first officer on the scene, Officer Santoro, found Mr. Andrews' wallet. It was sticking about an 1/8 inch out of his pocket. But all we know that was in the wallet was his driver's license and his retired JSO badge. But his money, his $1,132, was found in his right front pants pocket. So I think it's a reasonable inference that once he had to shoot him, he had to get the heck out of the cemetery, and he didn't go through his pockets. He may have gone through his wallet because, as I said, it was sticking out of his pants pocket. He may have not. I don't know that. But what I do know is the money was in his pants pocket, not his wallet.
And on the CCP, what ploy did Mr. Peterson use to get his stepfather to the cemetery?
Well, what happened is Mr. Andrews worked in a drug rehab center, which was less than a mile from the Green Lawn Cemetery. And Mr. Andrews was had left early at 9:30. Now, this was not testified to at trial, but it is in the record that he was leaving to go get his wife. And in order to go get his wife, he would have to drive down Emerson, which is the road close to the cemetery. And what the defendant told Jimmy Jackson is that he was on Emerson walking, and his stepfather picked him up, and he got him to go to the cemetery where he had left his girlfriend's truck. And he pretended to break down.
He knew his stepfather was going to be?
Well, I think that's a reasonable inference from the evidence, because he was there on Emerson at the time his stepfather was leaving the...
Okay, so he didn't... I had thought the stepfather left work because of some reason that Peterson had called him. No, we don't have that in the record.
In the record is evidence, statements given by Mr. Andrews' supervisor and co-worker that he was leaving to go change. Mrs. Andrews had a bank account, and Roy Andrews was not on that bank account. And as a result, Peterson had access to it or was getting money, essentially draining his mother's retirement accounts. And so Mr. Andrews wanted to go and put his name on that account so he could keep more control of it. Now, at the penalty phase, Mrs. Andrews was asked, and it wasn't narrowed down by the testimony at trial to that day, but Mrs. Andrews was asked whether they had that discussion about putting his name on the account, and she said yes. When she was asked whether she had ever told Peterson, she said no, but she said, well, he was in the house at the time. He may have been in the house at the time we had this conversation and could have overheard it. But I think, there's no reason why he would have been out on Emerson at 9:30 in the morning unless he had information that was going to happen, because it would be, I think, stretching coincidence to its limits to say that the defendant was out on Emerson, because he told Jimmy Jackson that was his plan. Pretend he was broken down. He was walking. Mr. Andrews picked him up, took him to the cemetery. When the police arrived at the scene, Mr. Andrews' hood was popped on this truck, but the hood wasn't up, but it was popped. So like you would go, if your son says, my car won't start, you go and you pop the hood because you're going to give him a jump or take a look. But so that was consistent with what the defendant said that was his ruse, was to lure him to the cemetery, to pretend his car was breaking down.
And he had a reason to tell him he'd be at the cemetery because his girlfriend was buried there.
No.
No?
The cemetery, he left his truck at the cemetery, and he was out on Emerson, and he waved him down.
But when he's telling his stepfather, we don't know.
No.
But the presumption is, my car broke down, my truck broke down in the cemetery.
I think it's a reasonable inference that he may have told that he probably told his stepfather, I went to visit Cheryl, and I couldn't start my truck. I think that's certainly a reasonable inference. Was there testimony to that? No. Is it a reasonable inference? Of course.
But the tape does say that he used that as a ruse to get the person to his vehicle.
Yes.
So that's clear. It's just they didn't fill in all the blanks in the conversation that was taped.
Exactly.
Okay.
And the defendant clearly had mechanisms in place to dispose of the truck, his clothes, and get back to hit the cameras, as he testified to, that he needed to get back and hit the cameras, and that's what he did to establish his alibi. If you'd like...
In this case, the aggravators were were they, I mean, I don't know, hotly contested, but you could have, I agree with you, there's evidence to support pecuniary gain, but someone else might think that it's not pecuniary gain, it was an anger. He doesn't have, and then you've got CCP, although I agree, again, there's evidence to support it. I could say, I don't know if it was really CCP. I mean, so if in terms of Ring, with the 7-5 jury recommendation and not knowing what aggravators were agreed on, if the U.S. Supreme Court case means what some of us think it means, isn't this a problem for the state in this case? Not maybe here in Florida, but ultimately that the jury, we don't know that the jury found the facts, they certainly didn't find them unanimously, upon which the death penalty is being imposed, that 5 of them didn't agree, that either there were aggravators or we don't know.
We don't know. No, it's not a problem. The United States Supreme Court has said that, the problem obviously in Ring was the fact that it was judge alone. I mean, the jury didn't have any participation in this. And in Hildman, the United States Supreme Court said that the jury's recommendation of death, as this court has recognized in Steele, is the necessary fact finding for finding an aggravator. I mean, this court's found this in Steele well after Ring, and just recently in Abdul, of course, this court found in a similar case where it was no underlying felony, no prior violent felony, and premeditated murder that Ring, and this court found 7-0, that Ring was satisfied. And so we have the same case. So no, I do not think that this case presents a Ring claim. Because of that, because the United States Supreme Court has already ruled that Florida's version, which does have a jury, and which, of course, the aggravator is implicit in the recommendation of death, satisfies Ring. So no, I don't think that. Justice Lewis, if you'd like, I'll talk about the victim impact and evidence just for a moment. Yes, Jack Andrews, I mean, the prosecutor did what you want the prosecutor to do. They have the victim impacts, the defense gets an opportunity to scrub it, the court gets an opportunity to scrub it. Now, that's not explicit in the record, but they do talk about the fact that these are prepared statements, and the defense counsel doesn't raise any issue about the statements themselves, and Jack did go off script. He went off and said 2 things. This is a horrific crime, and it deserves just punishment. Didn't make a recommendation.
Well, it defies, any logic to suggest that that's not what he was saying. So keep going. I'm listening.
The standard here, then, what you asked, what is our standard? And the standard is mistrial, and that is that one comment so vitiate the entire proceedings that a new penalty phase is warrant, and the state would submit that it's not. Overall, the very strong aggravators in this case.
Do you agree, though, that that's a, so we get some clear guidance here, that comment is beyond the scope of the victim impact?
Yes, absolutely. This court has said clearly that it's not proper to comment on a punishment.
I appreciate that. Now, how about on the part of his record of being a former police officer and all that? That was, is that properly part of the victim impact?
Of course,
in this case, because it describes who he was.
His uniqueness as a human being. There's 2 parts, and I think what Mr. Peterson is focused in on is how, that if you're a retired police officer, you have no more contribution to the community. If you're a retired, or if you're a former Army paratrooper like me, you don't have any contribution. Really? Yes, ma'am. A contribution to the community. So, but even if you accept that, which the state doesn't, then its relevance is uniqueness as a human being. And this court has on many occasions held that it's proper to actually say what the defendant or the victim is, and in this case, a retired police officer. There was no objection to any part of Chief Ross's testimony about in his victim impact statement. It was simply that he was an officer. And sort of that ties into the first issue about this comment. Prior to, at the suppression hearing, which is found in volume 18 of the record, the prosecutor announces that both the defense and the prosecution have met and scrubbed this statement out of, to avoid issue and any unfair prejudice that might stem from that, any implication that he killed Cheryl Greer. Now,
And in fact, we have in the record what was excised. And
absolutely, you have that in set forth in the state's brief. Also, in addition, at that hearing, the defense counsel says, Judge, I also want to redact any, at least during the guilt phase, any mention that he's a retired police officer. The court said, okay, we'll redact that too. So they redacted that too. And there was absolutely no objection to the I stacked them double. One thing is why it's critical. This man landed on her grave. That doesn't say who did it. That, you know, the defendant, when questioned during his testimony at the guilt phase of how he learned certain things that only the killer would probably know, was, I heard it somewhere. It would be easy to explain, I heard the man landed near my girlfriend's grave. I stacked them double identifies him as a killer and refutes any notion that somebody else did it. I mean, that was his defense. So, and it also refutes the notion that he was lying to Jimmy Jackson during his statement, because so many things tied him to the scene. The number of gunshots. Pop, pop. That's what got him. There's so many consistencies between what he told Jimmy Jackson and and the actual crime scene, including that the victim's body was found in very close proximity to Cheryl Greer's grave. And any notion the prosecutor suggested at any other point, in fact, never suggested that he killed Cheryl Greer. I mean,
how was it used in the penalty phase?
CCP. It's part of the evidence of CCP. The fact that he
had planned, he picked that spot.
Absolutely. And not only that, but that was part and parcel of his very cold and calculated plan to commit the murder. If this court doesn't have any other questions, the state would respectfully ask that you affirm his conviction and sentence to death.
Still, as to the last point, I think it still goes back. I mean, whatever relevance it has certainly is outweighed by whatever prejudicial value. So, to play this statement during the penalty phase, when they'd already decided he committed the murder, seems to me to go beyond the pale of admissible relevancy. Now, as to the pecuniary gain factor, this is what the trial court's order said. Laverne Rendell and Becky Bryce both testified that Roy Andrews had told the defendant that his lifestyle was not going to go on and that he had to move out of the house and that he and his wife were going to terminate the flow of money to the defendant. So what's clearly happening here is the court is using the hearsay of these two women, Laverne Rendell and Becky Price, to justify its aggravating factor, which this court says you can't do. Thank you very much.
We thank you both for your arguments. Come now to the last case on today's docket, Commercial Jet, Inc. versus U.S. Bank, N.A. Do you not wish to reserve any rebuttal time, or you're just going to kind of see how it goes?
Ask for 5 minutes, Your Honor.
Okay.
May it please the court. I'm David M. McDonald of McDonald & McDonald, and I'm counsel for Commercial Jet.
Might be helpful to pick that up a little bit.
Better? Thank you, Judge. We're here today to discuss the statutory interpretation of a couple of statutes. Sitting in the gallery, I listened to you all grapple with cases absolutely dealing with life and death issues. Maybe this case may not seem quite as significant, but I can promise you that it is very significant to the aviation community of this state.
Could I ask you a question at the outset? And
yes.
I would address it to both sides, because it seems to be essential to the resolution of this case. It seems, as I read some of the arguments and I read the third district's opinion, they're interpreting Chapter 713 as a lien only, or lien only, and created only if there's possession. I don't read it as being created by possession. As I read 713, it's in favor of persons who perform labor services under subsection 1. And then the statute goes on and talks about other things, but that it does say that it is released, relinquished, and lost by removal. So it seems to me there's two concepts here. The lien is created by the work performed, not the possession, but that if you give up possession, you lose your lien.
I agree as to 713, okay? Let's look back just a moment, Judge. If you look at Florida Statute 85.011, that's a statute that deals with enforcement of possessory liens. It dates back to the 1800s. 1970 comes along. We have this Florida Chapter 713. The first part deals with construction liens. The second part deals with miscellaneous liens. And in 1970, the legislature creates this statute, 713.58, which says that a person who performs work or services on the personal property of another shall have a lien against that personal property. Obviously aware of their prior enactments, black letter law of judicial construction, that the legislature is aware of their prior enactments, the legislature discusses that it's unlawful for you to remove your toaster from the appliance store and defeat that lien. And then it goes on to discuss about what happens if that lien is broken by fraud, by giving a bad check or stopping payment on a check. 13 years later, the legislature creates 329.5.
Well, can we just stay with the 713? Because, you know, and I'm not familiar with lien law, so I really am relying on the statute. I'm going, where does it say this is a possessory, that it arises only if there's possession? And you've got to go to the part where it says that in initial, I don't have my glasses on. It goes to the third section. It doesn't spell out.
Second and third paragraphs.
Like if you were teaching law students this, you'd be going, what would you'd say you filed the lien, or what is this? What is 713.58 do other than what you said, which is that if there's a lien, you can't go get your toaster, and it's then defeated. Why does it say that there's not a lien if you're not in possession?
Well, that's a good question, Your Honor.
I thought that was what Justice Lewis
That's what I'm asking. I'm trying to understand is that the statute seems to say that the lien is created, but if you give up possession, it does say that it's released, relinquished, and lost. But it would appear that you could file now under the Chapter 329 some kind of notice to perfect that lien in the records before you give up possession. I'm trying to see how this all works together, because it does, in my reading, respectfully, it doesn't say that it's created by possession. It's created by performing labor or services.
Well, that's exactly right. It is created by the performing of services and the labor. That is what paragraph 1 says. It doesn't say anything about possession.
Right.
But it is a statutory lien.
Right.
And 85...
Well, the third district doesn't even mention 85.
Judge, for 28 years, we in the aviation community have read 329.51 to mean exactly what it says. And what it says is that a lien under 329.41, which is for people who provide fuel to aircraft, or 713.58 is enforceable if you record a verified claim of lien with the court.
But the question is, how can you enforce a lien that has been released or relinquished by the surrender of possession? I mean, that's the problem that I see with your position, because it's one thing if you have possession and you perfect the lien, and that sets you off on the road to enforcement of the lien. Because this section in 329.51 is about enforcement. And I don't see how you can enforce a lien that has been relinquished by the surrender of possession. It just is that simple. And that's a very, it just seems to me to be transparently clear that that is the way these provisions would be interpreted.
But, Your Honor, if you do that, you completely ignore the rule of law that says that we look at the plain meaning of the statute of 329.51, which says that lien, if you record within the 90 days, that lien is enforceable.
But here's
No. I do not follow your logic there, because this, it seems to me to be the only way you can reasonably interpret 329.51 is that there has to be an existing lien with respect to which the notice is filed. And if you don't have an existing lien, then you don't have an existing lien. So there is nothing to enforce. And I don't understand. I mean, you're asserting that that's the plain language, but that's not. I don't see how that's plain.
But Your Honor, if that was all that 329.51 was attempting to accomplish, there would be no need for it, because then the only enforcement of the lien would be by possession.
But why couldn't it be? It says this is my problem, because I sort of, I'm reading what Judge Schwartz said, and it says, the beginning says, any lien claimed on an aircraft under 329.41, which is a lien for fuel furnished to the aircraft, or 713.58. We don't have a 4.1 lien here, and we don't have a 5.8 because at the time that the lien notice was filed, they weren't in possession of the aircraft.
Well,
so if the legislature meant plainly to create a lien freestanding from 5.8, all they had to say is a person who has furnished services to an aircraft has a lien upon the aircraft for any unpaid service charges.
That's referred to in the statutory title. Liens for labor, material, or services.
Notice. Okay.
Right.
But would you agree with that?
Notice.
That we got 4.1 and 5.1. They're right next to each other, and instead 5.1's referring to 4.1 and referring to 713.58. Well, that's the whole idea, is that why does that statute, 5.1, plainly create an independent lien when instead what they're doing is referring back to two other statutes?
I think that the lien exists against personal property in general under 713.58. That's what creates the statutory lien right.
But again, it creates it, but then it destroys it if they're no longer in possession.
But Your Honor, what you're forgetting about is the aircraft is not like a toaster that you can take.
I'm not forgetting about it.
Okay.
This is not us. This is the legislature.
All right.
Okay, and the issue really here is I agreed to grant jurisdiction on the basis that it looked like it was the specific statute should control over the general statute. But now as I read this, and read the briefs and look back at this, I see a statutory construction that maybe I would agree with you or maybe not, but I don't think it's a clear violation of statutory construction principles to, when you're looking at 4.1, to say this 5.1 isn't creating a lien. And if it's a question of statutory interpretation, then we don't have a basis for jurisdiction of conflict.
I think what you're about to say is that an airplane is not like a car that breaks down and you can tow it to a mechanic shop and they fix it and they don't give you the car until you pay. An airplane and Delta could have an airplane break down in Houston, and assuming their hub is in Atlanta, they will fly their experts down to Houston to fix it, and the plane goes back in the air again, so there's no way you could possess the airplane. So I can see that point, but I think what Justice Parent is telling you is that is an issue for the legislature. We can't fix it here that way.
I think that's what the legislature intended when they wrote 329.51.
Why did they do 4.1 differently? Why did they need 4.1 if they had 5.1? If you're correct, what is it? Why is fuel different than services?
I find 4.1 to be a remarkably interesting statute in that it grants a lien to someone who provides fuel. The airplane's filled up with fuel, it flies off, it burns the fuel, the value is gone, and nonetheless it gives the fuel provider a lien against the aircraft for that fuel. There's no betterment to the value of the aircraft.
But
like
you are
normally
now
see in
making a policy statement. It sounds like, Justice Labarga, I probably agree with you. It sounds like this would be a reasonable thing to do with aircraft. That is, to make a non-possessory lien. But you would agree that it's not up to us to rewrite a statute. So isn't your remedy really across the street to say, hey, we thought you wrote this, we've been doing this for 20, 30 years, but you need to say it this way? And I'm sure the aircraft industry can get that accomplished.
I don't think that's correct, Your Honor.
Which part is not correct? You just said it doesn't make sense for fuel to have a lien, but services not to. And what I agree, it might not make sense. It's not absurd. And they clearly created one for fuel.
But I think that they said that the legislature created a lien under 713 for people who provide services to personal property. With regard to that, when that personal property is specifically an aircraft, that lien is now not enforceable by possession under 85, Chapter 85. It is now enforceable by recording a claim of lien in the county where the work was done within 90 days of completing the work. Then they go on to tell you the semicolon notice part is, the last sentence of 329.51 says, this doesn't change your requirements to record with...
Why would 90...
I'm sorry. You know, your argument to me sounds like you're saying that these two statutes cannot coexist, that you cannot have a portion of 713 that says you lose it by possession when the other one, 329 is it, that says that all you have to do is file the notice to perfect it. But I don't see why those can't coexist.
Oh, I think they do.
If you had filed a lien, before you gave the airplane back, what would be the situation here?
Well,
if you had recorded it under
if you had recorded the lien, if you recorded the lien before possession was relinquished, and then the aircraft left, if you're going to look at paragraphs 2 and 3 of 713.58, if you release the aircraft, it's still waived. It's released.
Well, we don't
it's
have
gone.
that situation here. It seems to me there's a good argument to be made that that's how you would do it, that when they're in possession, you make sure so that before it's released, the person who's having it released knows that this lien exists. I mean, your client went to great trouble to say, you know, you got to keep it here for 90 days. If you don't pay it, we're going to tow you to someplace else. You're going to have to pay parking charges. I mean, the whole thing was about keeping this aircraft until the money was paid. So someone made a conscious effort to not go along with the agreement they had reached and let it go, and not having filed a lien. And now you're saying, what if the next step is somebody is going to buy that aircraft? There's 90 days that it's in limbo before the aircraft, that there's nothing that anyone would know and be put on notice that there's a lien?
Well, if you look at the prior cases, I don't remember the name of the case, but it was 1974-ish, where it was that type of case where an aircraft was at a repair facility, the owner abandoned it there, the bank who had a security interest in it foreclosed, they went to pick up their airplane, and the repair facility says, oh, no, you got to pay me the bill. And there's no notice, there's no record, there's nothing but possession. But under Article 9 of the UCC, it provides that a liener in possession has a superior lien than a recorded security interest. And so...
Go ahead, I'm sorry.
And so the The issue about whether there's notice to the world is really, I don't think, of great import here. What we have is, and what I think the courts below did, were that they looked at the interpretation of a general statute and made that control over this very specific statute.
But the problem is the specific statute makes reference to the general statute. And essentially, it just kind of effectively incorporates and refers to what's in the general statutes. It's not one where you've got something going on where you've got a general statute and then the legislature comes along and adopts kind of a freestanding specific statute. And so you could maybe see that there was an implied repeal that would arise from that. There's no implied repeal of this earlier statute because they refer to it, and furthermore, the particular provision that they adopt is not a provision about the creation of liens, which is what the other statute is about, but is a statute about the enforcement of liens. So your argument just, I don't see how it stacks up, but I have helped you use up a little more of your time here.
I would like one other question is that reading these two together, and even if you have a possessory lien, could it not be read that 32951 is modifying or limiting 713 if it says because is enforceable, doesn't say only, but it says enforceable when a lienor records the verified lien. So is it creating an additional requirement that to enforce one of these possessory liens, you have to within 90 days have recorded your valid lien?
Well, yeah, that's obviously a requirement, Your Honor.
Okay, so I mean, that's what that's
there was a
directed
case
to.
Out of, I think, the 4th District that dealt with the lien was recorded
right
in the county, but not recorded with the FAA as required by 32901, and the court said you didn't meet the recording requirements, it was not a valid lien. Here, Commercial Jet followed absolutely every requirement of this statute that provides that if you do these steps, you have an enforceable lien.
Except gave up possession. That was the only, that's a step.
Not clear on this record, but I think, with regard to these commercial aircraft, they have to get back in the air so quickly. They only make money in the air. And so there's this huge rush to get them in the air. You can't hold a 767.
Well, that's a lot of leverage to get the bill paid. I mean,
you would say that, but realistically, you don't even know what the bill is at that time.
But how long does it take to prepare this lien to record? I mean, isn't it a sort of form-driven type proposition? The form, how long does it take to prepare the lien?
Well, it doesn't take much time to prepare the lien at all, Your Honor. The problem is finding out what the cost of those last-minute parts were that came in just before you finished whatever was broken and sent the airplane back on its way.
Well, what about an estimation and the cuffs?
But that's not clear on this record, but we're a little off
there are ways to deal with that by getting deposits, and I mean, but you have used up all but about 45 seconds here, so if you'd like to reserve that.
I would like to reserve that. Thank you.
Good afternoon, and may it please the court. I'm Eric Wolf, counsel for respondent, Rachel Sullivan's co-counsel. The statutory text here works as the court's questions have suggested, and this case never gets past the first step, which is by releasing possession. There was no lien under 71358.
You're representing the Boeing company.
Correct.
Was the original case against the bank?
The bank is part of the plane's held in a trust, and the trust is with the bank. And the beneficiary.
Okay, so was it Boeing's plane?
It's the Boeing Capital Corporation's plane for all practical purposes.
And was it their plane at the time that it broke down and needed servicing by Commercial Jet?
It was on lease to Silverjet. Silverjet was a company that it was a British company. They thought they could make money flying all business class. They actually had the plane considerably remodeled inside. It turns out that's not a good business.
So how could Commercial Jet, trying to honor what we're talking about as far as getting aircraft in the air, have perfected its lien? What would they have had to do in this case, according to you?
They should have done what actually is the practice in the field. And Mr. McDonald referred to 25 years of experience. I went out and asked the folks at Boeing Capital Corporation, how does this really work? They said, they hold the plane. That's what they do.
So you read this as the 329 is really just, it prevents fraudulent liens, because you have to go in and file it in the county, but you still have to maintain possession. Possession alone is insufficient. This is to be enforceable, you have to file that notice.
That's correct.
That's why you would interpret this.
Although realistically, when you hold when you hold the plane and demand your money, they're probably either going to pay the money or file for bankruptcy. For all the reasons that
what's
were
the last
given.
part? Pay the money or what?
Pay the money or file for bankruptcy, because as Mr. McDonald correctly said, they want to get the plane back in service. While it sits there, it's not making any money. So
Can you have the situation, though, where if they file the lien at the time they have possession, that they can give up possession and still have filed under the then 329.51?
I think that question could go either way on the statutory text.
But that may be.
It's not presented in this case. I'll make 2 points on that. One is practical, and the other goes to kind of the overarching scheme here. The practical point is, once you insist on possession, and you see this in the cases that get cited in the third DCA opinion and in our brief, for example, Creston Aviation versus Textron, the Tradewinds case, the maintenance facility, and it's almost always a facility, especially for the big planes. I mean, this is not some person with a toolbox coming up to the plane with crescent wrenches. It's a sophisticated, certified operation, and they have their own facility. But once they insist on possession, they're going to get paid if there's any money to pay them. And they're not going to enforce through letting the plane go and filing a lien. That's not a route toward getting your money. And in fact, if that's what the maintenance world comes away from with this case, following what's being recommended, that's a disaster for them.
What about the fuel thing? If there's anything that seems like it's capable of immediately being ascertained. I mean, we all go to gas stations and we put our credit card in and we have to pay. Right. Why did the legislature create? Do we know? I mean, or is that just since we're talking about practical, real-life thing? Why,
sure.
Well, why does someone get a lien for gas?
I don't know the answer to that. It is interesting that they have a special provision. Maybe they had better lobbyists. I don't know. It's certainly possible. We don't see the reason why possession, we know that possession works very well, and I have that from people in the industry, but we also know it from the case law, because there just aren't very many cases. And the reason there aren't very many cases is people don't have to go get liens, because by insisting on possession, you get paid. Usually the only cases that arise in this area are far down the chain, in bankruptcy, the trustees trying to wrestle the plane away from someone.
I have a thought. Sure. If this was freestanding, 329.51, it actually might deprive the service providers of the best weapon that they have, which is possession, because it's really saying, under this interpretation, that 58 has nothing to do with it. Your lien is under that, and it's a non-possessory lien, and that's maybe going to be less powerful than keeping the plane.
I think that's absolutely right.
Is that, I mean,
and
there
the
might be a
fuel
flaw in that, but
providers,
it does strike me that that wouldn't be a good
the fuel providers have this lien right, but realistically, they're gonna demand prepayment. Yeah. And there's a GE case that was in, I think, the third DCA.
What does it cost to fill up your plane? No,
I don't. Mr. McDonald may know. I actually don't know. I do know. Just to be clear, Commercial Jet was not the only party that was stiffed by Silverjet. Silverjet was on a lease, and it was a lot more than $57,000 per month, and we were a creditor too. So they walked out on a number of others. Let me put the whole scheme into some context, which in retrospect, I wish I'd given this backstory in the brief. We included the legislative analysis, which kind of speaks to it somewhat obliquely. The FAA statute, it's 49 USC 44107, requires the recording of any conveyance that's related to airplane title. You have to file it in Oklahoma City in order for it to be valid. And leading up through the 70s and into the early 80s, there were a number of issues that were kind of percolating. And some of them had to do with, well, how does state law fit into that? State law says that I have valid title does the fact that I was late or didn't file with the FAA mean that I don't have title and somebody else does? Eventually, one of those cases went to the Supreme Court. It was Philco Aviation versus Shackett. And the Supreme Court said, here's how it's going to work. You have to file with the FAA to have a valid conveyance or valid interest in that airplane. But we'll look to state law for priority. Just before that is when Florida amended its statute. And the FAA was signaling this through the Federal Register because Florida, like some other states, had these possessory liens that didn't require any recording. You just hold the property, and they either pay or they go to the court and get a bond, and then you have to release the property, and then eventually we figure it all out in a proceeding. But you didn't have to record anything in Florida, which meant you didn't have an instrument that you could then file in Oklahoma City with the FAA. This provision, 329.51, brought Florida into compliance. Not compliance is not the right phrase, but it allowed the federal system to work properly. So 329.51 gives you an instrument that you filed in a state court or in a county in Florida, and then you have to go file that with the FAA, and you're done. And you are protected against third parties. You're in line to get paid. Now, realistically, I mean, the fuel providers might have to rely on that if they don't get prepayment. But the service providers, they're going to hold the plane. They're either going to seek prepayment, and the cases show prepayments of like $250,000 and whatnot, so in some of the cases cited. But they're going to hold the plane. They're going to get paid. That's how the system works. It's a cash on the barrelhead system. We've all seen airlines come and go. It's a very volatile business. You get your money up front.
Well,
and
mainly, I mean, because we're talking about all these, thinking of these large jets that are, we all have had delays and while they're doing maintenance. Usually that's by the employees of the, I mean, it isn't that situation.
And it's relatively minor. You wouldn't get off the tarmac, we would hope. Yeah. But that's not what we're talking about here. For example, I think it's in the Tradewinds case, it's a heavy maintenance check. It's going to take an extended period of time.
You're complying with all of the requirements.
Yes, and the fee at induction, when it goes in for this, is $250,000. That's a serious operation. You get that money up front, and when the operator didn't pay it, they held the plane. And they litigated in bankruptcy that they could keep holding the plane, and eventually that all got sorted out in bankruptcy. And of course, the bankruptcy context does show that it's a volatile industry. It goes up and down with fuel prices and you know, other things like that. So the reason for this provision, 329.51, is all about sort of harmonization with the FAA regime. That's why it was passed. It wasn't passed.
Was 4-1 passed at the same time?
I believe it was. I'm not certain about that.
And that was, you think, the best you can say about it, better lobbyists?
I guess. I have no idea. Those four provisions sit together. As you pointed out, they did not have a special provision for the service providers, but the service providers with the possessory right, they have all the leverage they need, and they can get their
unless
payment.
You've got somebody that's really thin, and then you want to help the owner get it back in the air so they can make money to pay the bill. So, I mean, it cuts both ways.
Yeah, it does, yeah. Although under Florida statutes, 713.76, they can get a bond. So the operator could go post a bond, and then they have to release the plane, or the toaster, or whatever it is.
Bond like you would in any other context.
Yes,
then. Yeah.
Yes, and then you can go. And there actually aren't that many cases that even deal with 713.58, but a number of them deal with the posting of bonds and the release of the property. Mm-hmm. So if there are no further questions, I'll sit down. Thank you.
Can I have his remaining 99 minutes?
You may not. You're going to have the remaining 39 seconds.
And counting.
A couple of things really quick. 329.51. It says a person who claims a lien. We have all been talking about a valid lien, but the statute 329.51 says a person who claims a lien under 713.58, meaning for having done work, shall have that claim is enforceable if they record in accordance with 329.
Well, I mean, you are asserting that if there never was a lien, and the mere claim of a lien gives them some right to enforce it. I mean, there's got to be the underlying basis there.
Right, which is the performance of work in supplying materials under 713.58. Another issue.
And the possession.
And I practice primarily in aviation law. I am aware of the laws in other states as a result of that. And this statute is remarkably unique. I'm not aware of any state that has a statute exactly like this. And so when counsel from Boeing, who's based in Seattle, comes and says the folks in Seattle say they never see this, well, we got some evidentiary issues there. But in addition to that, this is a unique statute that in Florida, you must interpret the statute by its plain language. And the plain language says that a person claiming a lien because they perform services on an aircraft, that lien is enforceable if they record within the time. There is no way to affirm the decisions below and give full faith and credit to every word of 329.51. I would ask that the court please reverse and remand this for further action. Thank you.
We thank you both for your argument. That's the last case on our docket today. The court will now stand adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University. You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.